This is an appeal in the matter of Walter Merricks, CBE and MASTERCARD Incorporated and others, part heard.
Good morning, my lord.
Good morning.
I'm addressing my learned friend's appeal. Can I start with what is common ground, please, as we've described in our skeleton? It's common ground, first of all, that prior to the 20th of June 2003, a private action for damages, as you know, for breach of competition law could only be brought in the civil courts under the general rules on limitation under the Limitation Act. It's also common ground between the parties that, pursuant to sections 2 and 9 of the Limitation Act, claims that had arisen prior to the 20th of June 1997 were prima facie statute barred. So as at the 20th of June, MasterCard had an accrued limitation defence to these claims, subject to any section 32 defence, which has been looked at separately.
That's not been...
Exactly. So that's the background to this argument. As the court saw yesterday and knows, from the 20th of June 2003, section 47A of the Competition Act 1998 took effect, pursuant to amendments to the Competition Act made by the Enterprise Act 2002. We looked at section 47A yesterday, and can we just turn that up again so I can have it in front of making submissions? It's behind the judgment, I think, my name is right.
Page 198.
Exactly, thank you. And as you see, the section applies and specifies in section 1 to which claims it applies, and it only arises subject to the text at the end of the paragraph where there's been damage as a result of an infringement. If you then look at paragraph 3, you see that for the purpose of, and I emphasise the word identifying claims, which may be made in civil proceedings, any limitations that would apply in such proceedings are to be disregarded, and a claim to which this section applies may be brought in proceedings before the tribunal.
So 3 is just an identification.
Indeed. And that's precisely...
My Lord Justice Snowden put to Ms. Demetrio, yes.
And that's precisely what Mr. Justice Barling found. I'll show you that briefly when we get to it in paragraphs 56 to 58 of Deutsche Bahn.
So claim in 1 is a claim of a type,
Exactly.
setting aside any issue of limitation.
Exactly.
We're not looking at claims which are live, we're just looking at claims in the round.
Exactly. That's exactly right, my lord. And that's exactly what Mr. Justice Barling found. And just to, and I'll come on to show you, just so you're aware that in the application for permission, my learned friend accepted that the findings of Mr. Justice Barling on that point were good law. That was part of the application for permission. So on that premise, you see then the 2003 rules then taking effect, and this is at page 204. And the 2003 rules were made under section 15 and part 2 of schedule 4 of the Enterprise Act. And rule 31 introduced new limitation rules for follow-on claims. And
what did those enabling provisions actually say? Were they in just very general terms, just saying you can make rules in relation to limitation, or was it more specific?
you're talking about sections 15 and part...
Section 15 is under the Enterprise Act. It's just a power to make
Exactly.
CAT rules.
That's right.
And the Secretary of State, I mean, they're obviously drafted by somebody else, but the Secretary of State made the rules from recollection.
That's right.
Yes, it's a subordinate legislation power conferred upon the Secretary of State to make rules, which includes limitation.
Yeah.
There's nothing. It's always very important to go back to the enabling power to see what Parliament intended when it conferred something. Did it intend to take away rights or grant rights? If it's a very, very general power, you generally construe that relatively restrictively so as not to undermine existing rights. It can be rebutted, but to rebut that, you require some very clear contrary provisions.
And that's precisely, my lord, the point you made yesterday about this. It would be surprising to abrogate through secondary legislation in the first place, and particularly so, as I'm going to say.
It's the Secretary of State's given powers to make rules.
That's right.
Tribunal rules. You say, it would, at least on the face of it, one wouldn't expect that to include abrogation of
Exactly.
statutory right given by primary legislation.
That's right. And so what we suggest is that rules putting forward the new regime were in 1 to 3, and Rule 4, 31.4, was not in fact needed anyway,
Well, I wondered about that.
because 31.4 simply is at best a clarificatory statement to avoid confusion, but because there is would not be on the face of either my Lord Justice Green's point, this legislation taking away through secondary rules accrued rights, but also, as I'll come on to show you, and I may not need to, the Interpretation Act makes it plain you couldn't do it except through very, very clear words. And there is nothing in the Competition Act section 47A that purports to take any rights away.
Well, there's nothing retrospective.
Exactly. And you would need
This is effectively looking backwards rather than forwards.
That's right. And 31.4 is, as we've called it, a belt and braces provision. And I can see that it was included to make it plain that so there's no confusion that anything is being done. But of course, it's simply recording, if you like, what was the legal position, as opposed to making, including a rule that had the power to preserve. It's not a preserve, if I can put it that way, it's not a preserving position. It is a clarificatory provision. I know it has been described as a
changing the
saving.
law, is the point.
Exactly. And can I show you, as I've made the point, I know you're familiar with this, but I'll just show it to you, the Interpretation Act, which we rely on, it's in tab 1 of the authorities bundle, and it says very clearly, as my Lord Justice Green knows, where an act repeals an enactment, the repeal does not, unless the contrary intention appears, I emphasise the word appears, revive anything or affect any right, privilege, obligation or liability acquired, accrued or incurred under that enactment.
Sorry.
It's tab 1, sorry, I raced through that, tab 1 of the authorities bundle.
Yeah.
Law is generally constitutionally allergic to disturbing
Exactly.
retrospectively through legislation, even primary legislation, acquired rights. This would be through secondary legislation.
Exactly. So we say that you would have to have something very, very clear, and it wouldn't be through this mechanism anyway, for taking my Lord Justice Green's point.
But I'm not sure what the act repealing an enactment, I mean, this doesn't directly apply.
No, it's the
This is dealing with repealing enactments. I mean, I understand the general point, but
I'm going to show you the yew tree case, which I think applies the principle.
yes, the principle.
That is the principle
That's it.
to secondary legislation.
It applies it. Let me show you the case. It's
Yeah.
secondary legislation. It's at tab 16.
Displace sections to allow.
And just before I go through that case, in answer to my Lord Justice Snowden's point, this is of course displacing the Limitation Act,
What is?
section 47A, in respect of these claims in this way. It's displacing for these purposes, not generally. It's not repealing strictly, but it is having.
Section 47 at the, sorry. This point I put to Mr. Michu, on reading, and I think it is the reading of the tribunal, but 47A 3, as initially added, actually has nothing to do with limitation. It's an identification provision.
Yes, and
For the
then you've got.
allocation of jurisdiction in paragraphs 1 and 2.
That's
It
right.
basically says, if you're a clever clogs who says you can't bring a claim in the tribunal because your claim is statute barred,
Yes.
the answer is no. This is just identification in 1 and 2 of the type of claim that can be brought in the tribunal.
That's right, and then
And
Rule 31 is displacing.
Is the one you
Sorry.
need to look at.
Yes.
So it's not, I mean, I didn't
Sorry, I
understand you to be
confused the-
accepting that 47A had
No.
anything to do with.
Sorry, I meant to say Rule 31 is displacing
That's
the Limitation
different.
Act.
That's completely different.
and
That's
that's
the
why I'm-
that's the streamlined argument, as I put it to Mr.
Yes.
Ritchie. Yeah.
And that's why I'm saying that if you look at if you're going to look at it in terms of displacing, then the Interpretation Act, by analogy, which talks about repealing, then comes into play.
But we actually don't really need to go through the Interpretation Act because in fact, there's a more general principle which you're about to take us to in the authority, I
Indeed.
think.
Indeed.
Yeah.
So it's a little bit of a segue.
Indeed, it's simply because U-Bond 2, I think,
Yeah.
applies the Interpretation Act. So it is in tab 16, and the relevant paragraph is at 563D of the judgment. Which is at page 114 of the bundle,
563.
and it's 114, 563 at the top, and letter D. The accrued right to plead a time bar, which is acquired after the lapse of the statutory period, is in every sense right. Let me read that.
Okay.
And this was a construction of primary legislation.
It was.
This principle also applies in ultra vires cases, so that if you have secondary legislation trying to take away, particularly retrospectively, an acquired right, you go back to the primary power and say, did Parliament intend it to have that effect? And the answer was invariably no, it can't do. Unless you've got the most explicit statement from Parliament, you're going to do something which is otherwise almost dramatically unconstitutional.
Indeed. So, if I can then move on then to the new section 47A, which amended the previous one. This was at page 200 of the core bundle. And this introduced us, my Lord Justice Snowden picked up, I think, the extra provision relating to prescription. And then a new 47E was inserted. And that provided for essentially the Limitation Act regime to come back for claims from the 1st of October 2015. And it applies to proceedings under section 47A and also collective proceedings. And then we then have the transitional provisions in the rules at page 204 of the bundle at rule 119. So the context then, just standing back, is you have up until 2003 the Limitation Act applicable. You have a regime between 2003 and 2015 subject to it falling within 47A of claims within that period to which the relevant 31(1) to 3 applied. And then you have from the 1st of October 2015 going back to the original Limitation Act regime. And these transitional provisions simply cover the period for which the 2003 Act applied. And the reason, if there needs to be one, that in 34(1)(4) was not needed to be referred to here is twofold. One, because, as I've already submitted, it was never needed in the first place. And two, because logically, when it was included in the 2003 version of the rules, it was looking to the prior period before the Act came into play in 2003. Here, these rules are purely concerned with the period prior to when the 2015 Act comes into force. So there is actually a reasoning behind it if one needs it. But what you can certainly say in answer to my Lord Justice Green's point, and I think it's the same point that you've just made, if you forgive me, is that if you look at the intention and purpose of the provisions taken as a whole, what you see is an intention to preserve existing limitation rights whilst introducing at different times new regimes going forward. What you absolutely cannot find is any discernible intent to abrogate accrued rights. Now, against that framework, Mr. Merrick's case is, as you know, that the transitional provisions in the 2015 rules abrogated the limitation rights that had accrued, and more than that, that the consequences that the claims which had been time barred for 12 or so years suddenly sprung back into life. And not only is this extremely odd, as the Chancellor said yesterday at day 2, page 177, we suggest it's not sustainable for 6 reasons. The first we've covered, which is that it's well established that the expiry of a limitation period confers rights which are not affected by subsequent legislation unless unless it's clear and unequivocally clear. And Mr. Merrick's case therefore starts with a problem for all the reasons my Lord Justice Green's identified in the secondary legislation position, but also because his case is that it's done by a silent omission of a rule. And the case has to be that that unavoidably leads to the unequivocal conclusion that established limitation rights were abrogated. My learned friend said yesterday that she was in fact interpreting the words used because she was saying she was focusing on what was there as opposed to what wasn't there. But there are 2 points to be made to that. One, that assumes section 31(4), first of all, was necessary, which isn't the case. But secondly, there are no express words upon which my learned friend can in fact focus, which remove the accrued limitation rights or even make it plain that the failure to refer to 31(4) was done with that intention. So in fact, you end up with it being a case about pure omission and inference.
Yeah.
The second flaw in Mr. Merrick's argument is that it was, as I've said, not necessary for the 2015 rules to refer to Rule 31(4) in any effect, and I've covered those points. The Chancellor made the point yesterday that it was most likely that it was omitted from the 2015 rules because it was seen as a historic provision, and we agree. And we can also see structurally it probably had no purpose anyway in transitional provisions. And the third flaw in my learned friend's case was the one highlighted by my Lord Justice Green. My learned friend was actually asked in terms what the purpose could be, which was fairly put to her. And in fact, was unable to and did not answer the question at day 2, page 191. And in fact, the point was covered in the DSG case at paragraph 60 to a point, because one of the other points that my learned friend didn't address was if you had the intention to abrogate accrued limitation rights, why simultaneously would you introduce new provisions preserving or giving limitation defences preservation by the new provisions in the 1st of October 2015. It just doesn't make sense as a whole framework. No. The fourth reason why Mr. Merrick's case can't succeed is that it's already been considered and rejected authoritatively in the DSG case. And if I can just show you that decision, because I think the point is made that it's not binding because the 2015 rules weren't a fundamental part, if I can put it, of the reasoning. But we suggest that's wrong because the Chancellor had to, in fact, look at the 2015 rules in the process of construing 2003 rules.
Is the argument that it's not obiter?
It's the argument it's not obiter, but it doesn't matter to me. It really doesn't matter.
Tab?
It's tab 34, my lord. It doesn't matter whether it is or isn't obiter, because the reality is that the reasoning is correct. And this court would need to be satisfied that the reasoning was in fact wrong or there was something different.
34.
So if I could,
34 is the cat.
and then the Court of Appeal judgment is behind at 1205.
35.
It's the same tab.
Okay.
And
Which paragraph?
my Lord the Chancellor may
Which
remember
paragraph
this.
do you want to look at?
If you could start first of all with paragraph 2, which is the question. The statutory background is then covered from paragraph 9 onwards at page 1212.
Yeah.
And the relevant reasoning starts from paragraph 52.
Yeah.
And what had happened in the tribunal below is relevant to the question of obiter, because below what had happened was that the tribunal had reasoned backwards from the 2015 rules, whereas the Court of Appeal said that that was the wrong way round. You reason from the 2003 rules forward, but both sets of rules were therefore considered. And if you start with paragraph 55, please, 50 or 54, these are the key paragraphs of the decision. And crucially, the court found that the saving would have been looking back to the previous limitation regime and preserving accrued rights. And similarly, the same point is made at the last sentence of paragraph 56. And you see then over the page on 58 the point I made about reasoning back. And the Chancellor then, the then Chancellor, goes on to discuss further the argument that my learned friend is now putting in paragraphs 59 and 60, and the court rejects it.
So not a principle that the chancellors disagree with their predecessors.
Try not to.
Or possibly indeed himself.
Yes. I mean, the point that's made at the end of paragraph 56 is the point we just debated, isn't it, as to Rule 31.4, that it was looking backwards.
Indeed.
And really, and I think that, he doesn't use the word confirmatory, but I mean, that's essentially the same point as you were making.
Exactly.
So what it's doing is confirming what the position already was.
Indeed. Because
So in one sense, as you said, it's probably unnecessary.
Indeed, because if you start from the position that the rules didn't have the power to confer any rights, so they must have existed.
Well, if somebody had
Therefore,
made a claim that was already time barred,
yes,
then it would be time barred.
yes,
That's all that's saying is, well, it's already time barred.
yes, exactly. But I think what I was saying was picking up on my Lord Justice Snowden's point, that either you have to say that 47A got rid of all of the limitation regime and therefore you needed 31.4, or 31.4, you have to read 31.4 as somehow conferring the limitation right as opposed to recording that it already existed. and you can't read 31.4 in that way,
Mm.
which is why it's got to be confirmatory rather than anything else. And what you then see in paragraphs 59 and 60 is the rejection that of the argument about the 2015 rules, removing accrued rights and reviving those claims. So 2 points. The first is that the Chancellor needed to and did consider the 2015 rules in order to address that argument, which was part of the argument before the court because of the way the tribunal had approached the decision. And secondly, he noted the inconsistency, I think the point you made, and arbitrariness that would arise because you would have certain claims being statute barred and others not, which were plainly not what was intended.
And he makes the point in 60 that you've also got 47E,
That's right.
and it would be even more wrong if 47E is reintroduces the Limitation Act if that, as it were, with one hand, and then with the other hand, the legislature had taken away
Precisely.
accrued limitation rights under the Limitation Act.
Precisely. He says it's
Doesn't make any sense
illogical.
at all.
Exactly. And he then goes on, as you've read, to explain why the argument should be rejected. And paragraph 61 is the conclusion. So we say that that answers the point, and it's been considered, and there's nothing new in my learned friend's argument. The fifth reason, I said there were six, the fifth is the point my Lord Justice Snowden picked up on yesterday, which is there is a real difficulty on Mr. Merrick's case on prescription. And that also demonstrates why the case doesn't work, because it leads to the contention that the draftsperson must have intended only accrued English law limitation rights to disappear, but accrued Scots law prescription rights not to be. And yesterday, my learned friend was forced into two different interpretations. This was at day 2, pages 215 to 218. The first was to say that the absence of any reference to prescription within Rule 31.4 meant that an otherwise extinguished claim could still have been brought before the tribunal. As my Lord Justice Snowden said, that can't work because an extinguished claim under Scots law isn't subject to a defendant's limitation defence. It just doesn't exist. So the second interpretation that was put forward was to read in to 31.4 the word limitation and prescription. So it's said to encapsulate prescription within the word limitation into 31.4. So in the end, when you stand back, the argument you're being asked to accept is that the omission of 31.4 not only operates on its face as an omission, but within it, one has to have read into it that it also covered prescription. The sixth reason why it must fail relates to 47A4, and we've looked at that. The statute says in terms it's for the purpose of identifying claims, and as we've already discussed, it was a jurisdictional point. And I said I would show you the Deutsche Bahn passage just to do that. That is in the authorities bundle at tab 29. It's Deutsche Bahn and Pilkington. it's paragraphs 56 to 58. 29, yes. And it's page 837 of the bundle.
Sorry, give me the paragraph again.
56, please. It's 837. And if I could ask you to read 56 to 58. Just to give you the references, in seeking permission to appeal from the tribunal, Mr. Merricks accepted at paragraph 14 of his skeleton that for the purposes of the application, he was taking the tribunal to have properly articulated the law in Deutsche Bahn, specifically that the effect of 47A4 was that limitation or prescription rules will continue to apply for all other purposes, save as overridden by express provisions elsewhere in the rules and the Act. And the same position was then taken in paragraphs 38 to 40 of my learned friend skeleton for this hearing. I think yesterday there was a suggestion that that wasn't the case because there was other references in the other rules. That wasn't part of the argument, but it doesn't work for all the reasons I've given you. So for all those reasons, we suggest that all four of the grounds of appeal should be dismissed. Just to remind you, the four grounds were that, first of all, the tribunal erred in relying on DSG, and we submit that that ground fails because DSG was correctly decided, irrespective of the obiter or not point. And we address this at paragraphs 17 to 25 of our skeleton. Secondly, it said that the tribunal erred in finding that it was illogical for proceedings commenced before the 1st of October 2015 to be subject to a time bar, but those after not to be subject to it. The answer to that is that it was clearly right. The Court of Appeal in DSG recognised the illogicality, and my learned friend was unable to answer why there would not be an illogicality. And we address that at paragraphs 26 to 30 of our skeleton. The third ground was that the tribunal failed to address why Rule 31.4 was included within the 2003 rules and why it was omitted from the 2015 rules. That, in fact, forms no part of the relevant legal test. The only legal question for the tribunal was whether the 2015 rules led unavoidably to the construction that there was an intention to abrogate existing limitation rights, and we've addressed that in our skeleton at paragraphs 31 to 35. But in any case, there is a good reason. The fourth point is that the tribunal erred in finding that section 47A4 of the Competition Act does not have the effect of disregarding the limitation and prescription regimes that would otherwise apply to these claims, and that ground fails because the purpose of section 47A4 is clear on the face of the statute and was correctly determined in the Deutsche Bahn case. And we address that in paragraphs 36 to 43 of our skeleton. So unless I can assist you any further, those are my submissions.
No. Thank you.
Lords, I'm going to reply briefly on one point because I think otherwise you have the measure of the arguments between the parties. But it's, in my respectful submission, the central point, which is my learned friend's submission that it's not possible, it would be surprising to abrogate limitation rights through secondary legislation. And in relation to that, we say that on any view, the rules, Rule 31, 1 to 3, do abrogate the Limitation Act. On any view, they do that, as the Court of Appeal held in DSG at paragraph 54. And that's the point about the particular displacing the general. So once Rules 31, 1 to 3 were enacted, the Limitation Act was displaced. So it was abrogated. And then 31.4, once the Limitation Act was displaced, then 31.4 was necessary in order to preserve accrued rights under it because the Act had gone. So that's why it was necessary. It's not possible to view it, as my learned friend does, as a belt and braces provision. Because the Act has been displaced, that means no one can rely on it. So if you've got a right under the Limitation Act, because it's been displaced, the starting point is, well, you can't rely on it because the Act's not there anymore, there's a new regime. So 31.4 was necessary. You needed a preservation of rights under the Limitation Act.
That's an argument that suggests that the rule is intended to be a retrospective effect, which can't be correct.
Well, my lord, I think that with respect, once you have a displacement of the primary regime, it's displaced.
Displacement for the future, though.
Well, it's just displaced, and then there's a question.
What's time barred already remains time barred.
Well, my lord, that's the area of debate, but we say it's just displaced, and so that's why there's then a question as to whether rights should be preserved. And so that's why the legislature had to step in under Rule 31.4. So I understand the point you're putting to me, which is that accrued rights are important and the legislature shouldn't abrogate them unless there's a good reason for that or unless it's clear on the face of the legislation. But the fact of replacing the Limitation Act, the effect of that is to remove rights, and that's why 31.4 was necessary. And so we say it's wrong to read it as a belt and braces provision. It was required. That was the legislature addressing its mind to the question of retrospectivity. It was saying, well, we need to preserve these rights, and we need to do it through Rule 31.4. Now, much of my learned friend's argument hinges on Rule 31.4 being unnecessary, and we say that's incorrect, and that's really the key point in the case. Now, once it's accepted that Rule 31.4 was necessary and has an effect, then you need to give effect to the deliberate omission of Rule 31.4 in Rule 119, which was the point that the tribunal accepted in DSG. And on my learned friend's case, there is no meaning given to the omission. So we come back to the central point of statutory construction. So, my lords, aside from, I think, the point about whether the Court of Appeal's decision was obiter, which we say it clearly was because of the last sentence of paragraph 59, which explains that the proceedings that raised this issue had been settled and so the court wasn't being asked to rule on it. I don't have anything else to say by way of reply because I think you have the measure of the party submissions unless you have any questions for me.
No, thank you very much, Mr. Mitria. Right.
Yes, my lords. I'll be dealing with the exemptability appeal. My lords, MasterCard, of course, recognises and accepts that the Commission held in the decision that it had infringed what I will call Article 101 just to avoid the various renumberings that took place over the period, during the period 1992 to 2007, and that finding of illegality is, of course, binding on us. And that necessarily means that MasterCard cannot seek to justify its actual EEA lifts, since that would contradict the finding of illegality in the decision. However, what MasterCard wishes to do in answer to this damages action is to show that alternative, lower EEA lifts would have met the criteria for exemption and have damages assessed, and damages should then be assessed accordingly. And that is, with respect, no different from a defendant in a follow-on price-fixing cartel case seeking to show that the cartel had only a limited effect on prices. And you don't, in a cartel case, calculate damages on the basis that without the cartel, prices would be zero. You determine what part of the actual prices, the overcharge, was caused by the illegal conduct. And in the same way, we say there is no reason to prohibit MasterCard from arguing that an alternative lower EAMIF would have been lawful, and so the overcharge in our case is limited to the difference between the actual EAMIF and the putative alternative lower EAMIF. And we rely upon 3 points to showing that lower levels of EAMIFs were potentially exemptable. And obviously at this stage we're not worried about whether they are or not, that would be a matter for evidence, but we just rely upon 3 points of showing this is a realistic point essentially. First, in 2002, so in the middle of the period covered by the Commission decision, which is 92 to 2007, the Commission granted Visa, which this court held in Sainsbury's was a materially identical scheme, a 5-year exemption in relation to its EAMIFs, which previously had been broadly at the same level as MasterCard's EAMIFs. It did so on the basis that those EAMIFs would fall by, in round numbers, approximately 30% over a 5-year period.
Yeah.
Now, my learned friend fairly accepts at paragraph 75 of her skeleton argument that she says it's perfectly possible that if MasterCard had argued that Visa did in respect of its MIF, that lower levels of its EAMIFs would meet the criteria for exemption, the outcome of the EC decision would have been different. And a similar point is made in the judgment at paragraph 139. And with respect to those, that's unsurprising really, those kind of acceptances. Given the Visa exemption decision, we have a clear idea of the kind of level that would have been acceptable to the Commission at the time. MasterCard tried to do better, it failed, but we have a clear idea of what the Commission was in principle willing to accept in that kind of time period. Secondly, as I'll come to show the court, Recital 13 in the EC decision expressly raised the possibility that MasterCard would be free to set new EAMIFs, especially said you can't carry on with the existing ones, but you are free to set new EAMIFs provided you can put forward the evidence to show those new ones meet the criteria for exemption. And third, but following that invitation essentially, following the decision, after discussions with the Commission, in 2009, MasterCard did set new EAMIFs. Those were approximately 70% lower than its previous EAMIFs covered by the EC decision, and the Commission accepted broadly that it was happy with those as meeting the criteria for exemption.
I'm not sure why the second and third points are relevant at all. I mean, because they're just saying for the future you can have another go if you want. But that doesn't cover the claim period.
Well, we're up on that. I mean, there's no, well, what we would be saying is there's no suggestion there was any material change of circumstances. There was in practice an 18-month period there. So it gives an indication of, in those market circumstances, the levels of EAMIFs that the Commission thought were acceptable. So it's not talking about some radically different time period. It's in those market conditions at the time, an indication of what was acceptable. But ultimately, we would of course have to.
That's an argument. The argument actually that you, as it were, could have set acceptableness during the claim period is one that you didn't run, chose not to run, didn't do.
My lord, that is undeniable.
And your clients must have known about it because Visa was in 2002.
Yeah, that was
So
publicised.
this is when the Commission were crawling all over myths generally. And for whatever tactical reason, your clients chose not to run the point.
Well, what we chose not to do is what Visa did, which was offer to reduce its myths to that level.
You chose not to suggest to the Commission that there were lower rates of EEA myths that would have been exempt.
Well, it would have been, always been, not would have been, but what Visa did is offered to reduce and said, if we reduce in this way, will you be happy with those?
Yeah.
But no, I mean, that is undeniable. My clients sought to justify their actual EEA.
So it's why it boils down to really 2 points of law. And I mean, was the cap bound in law? If not, isn't it abuse of process to rerun something which you could have done but didn't?
Absolutely, and that is exactly where I'm going. But the starting point is just to say, I'm not running something that is sort of pie in the sky, recognising, of course, the Court of Appeal, this court, and the Chancellor was not impressed with our arguments in relation to EMIS previously, but we've understood what the burden we would have to meet in the future going forward is. But showing these are realistic points. I'm not suggesting that these, ultimately comes out, the legal points, as Lord Justice Green says, are the legal points.
Yeah, sure.
Now, as you say, essentially there are two reasons here that the tribunal found, and there's my targets. One, whether the EC decision made binding findings that sort of preclude this, and secondly, the abuse of process point. And I respectfully submit that the tribunal erred in relation to both findings. And starting with the tribunal's conclusion on the decision. The important starting point here, I submit, it's a point we make at paragraph 85 of our skeleton, is that MasterCard notified its actual EEA-MIFs to the Commission. And as a competition authority, the Commission's role was to determine only whether those actual EEA-MIFs complied with or infringed competition. If we proposed something else, it would have then looked at those. But we notified our actual EEA-MIFs, and that is what the Commission reviewed. That necessarily means the Commission was only considering our actual MIFs and not some hypothetical alternative. And legality with respect here is a binary question. It's a two-stage binary question in the sense there's restriction and exemption, but the end result is a binary question. Either the notified EMIFs are lawful, maybe sort of part of 101, or they're unlawful. So that was the binary question the Commission had to determine. And with respect, we say the tribunal's analysis of the decision ignores that critical starting point, which is what is the role, what is the Commission having to decide?
The Commission decision isn't, when you look at the recitals, this isn't exemptable, it is just simply there was a violation of 1011. And that is because exemption is simply one step on the way to that ultimate finding. Just as a finding of effect is or relevant market, just one step along the way to that finding. So the question is, when the court looks at it and it's bound by that end result, there was a violation of 101, how many of those intermediate steps, exemption, effects, relevant market, can it revisit when it looks at damages? Can it reopen absolutely everything? Or why should it open exemption as opposed to restriction of competition or relevant market or relevant counterfactual for effects and so on?
I mean, obviously we're in a different world in the sense that obviously MasterCard appealed and that went to the European Court. The European Court ruled against us, but then you get rulings of law, and clearly the Court of Appeal and Supreme Court in the Sainsbury's cases have ruled about the impact of those rules of law. So that moves it into a different territory when we're in the principles of law. If one was looking at, looking simply in a world where there was only the decision, which we're not in, then you would be in the case of sort of any situation where somebody puts forward a different agreement, you would, in the world we were in then, show respect towards the Commission's reasoning. It wouldn't be binding necessarily, it would be very strongly persuasive, but as a practical matter, it would be very unlikely it would not be followed when the logic and reasoning flowed through. But for my present purposes, my point is that what the decision itself does is decide on the actual EMIFs, and that's what I'm going to show you is the thrust of my first submission. If the court could have open for this purpose, the tribunal's judgment, which you'll have, but that's core bundle tab 6, and then the Commission decision, which is at tab 45 of the authorities. I think the tribunal have two bundles, sorry, the court has two bundles of authorities, doesn't it? Or you have 2 or 4, just in, or 6 now, I think. Oh, 6. Well, 6 now, but yeah.
7.
Okay, this is in authorities 4 for my,
It's
in my bundling. I think there's
tab 45.
different people have got it in different numbers of volumes, which is unhelpful. Tab 45 for these purposes.
Do you want to go to the Commission decision first, or what?
Well, I was going to start with the tribunal judgment first to see sort of the bits that they focused on.
Just before we get to that, at tab 45, we've got something that is headed the non-confidential version,
Yes.
right? Why are massive chunks of it redacted and by who?
So the answer to that, and I think this is only historic in the sense that the confidential version is now public in these proceedings.
Yeah.
So this is the version that the Commission published at the time, or that was printed, went to the website, it went to the website in about 2009, it takes a while. So the Commission decided to publicise a version that redacted certain information based on submissions from MasterCard about confidentiality. So these are redactions made by the Commission, and this is the version which is non-confidential in the sense it was publicly available.
Right,
But given that the confidential version is out there, and I think we saw it, I certainly saw it, it's a bit surprising that that's not the one that's been put in the bundle. But anyway,
My Lord,
well, especially when, for example, if you just look randomly at page 1637, I assume that somebody very helpfully sidelined for our purposes of reading paragraph 78. And it took me
it's
a
going to
long
be
time.
quite difficult to read.
It took me a long time to read that.
My Lords, I can only apologise for that. You're quite right.
My lord, I don't know why this has happened, but I think somebody's realised it's happened. So if you look over the page, you'll see, I think, the redactions lifted. So there's a duplicate.
Somebody's put that in.
Someone's
at
put
page
it in, and I'm not
1637A.
sure. I'm sorry, I'm not sure how this has come about. It's obviously not very helpful, but you'll
Okay.
see it there.
I think that may have happened after I looked
The most
at it.
helpful thing, unless there's some objection, I don't at the moment see how there can be, is somebody, don't do it now, but somebody at some stage, possibly over lunch, simply replaces tab 45 with the confidential version.
Well, it's a public document. Right, it's a document that's available in these proceedings.
The unredacted.
Unredacted version.
I think actually the position may have been that this was the version that may have been in front of the tribunal at the hearing below.
Yeah.
Because at that point there was still a question about which bits when the redaction was lifted, and I can't now
Anyway,
remember when it became available.
we've
but
had our
no,
whinge,
yes.
Mr. Cook. Let's have a look at what we've got.
Yes. So let's pick it up then, firstly, with the tribunal's judgment, which is at paragraph 133, so page 178. So 183, sorry. So if we look at the top of the page, let's go back over to page 182, bottom of paragraph 132. It's an analysed basis there, and this is recording this Demetrios submission. It says, MasterCard arguments fails, and as a result, the Commission made a broad finding of infringement with no part of service exempt. So that was the argument. And then 133, the tribunal says, we think that submission is correct. Clear that Article 1 of the operative part of the decision stated, and then it sets out the bits of the operative part of the operative part of Article 1, which it focuses on. So I will then now turn you back to the operative part of the decision, which is page 1820, and then this at least functionally is not listed. These last
I'm sorry, Mr. Cook, you're facing that way, I can't hear you, sorry. Thank you.
So this is the operative part of the decision, and we're all familiar with the fact that this is the bit that is the decision. This is binding, plus such part of the Commission's reasoning, as is the recitals, as is a necessary part of.
This is Article 1, is it?
And this is Article 1, and in reality, Article 1 is it. Article 1 is actually the finding. Articles 2 onwards are then implementation provisions about the steps we should then take. So the court could, I'm sure you've had before, but could read Article 1.
Yep.
So it's a finding that during the period stated, 92 to 2007, the MasterCard payment organisation have infringed, finding of infringement, Article 81, also Article 53 of the EA agreement, by in effect setting a minimum price merchants must pay to their acquiring bank to accept payment cards in the European Economic Area by means of the intra-EA fallback interchange fees for MasterCard and Maestro branded cards, consumer cards. Now, I emphasise in particular there the second part of that, which is the infringement is by means of the inter-EA fallback interchange fees, which is 2 points in particular. Firstly, it's by means of, so the infringement that is found is by means of the EEA MIFs, and it is the definite article, the EEA MIFs.
The crucial words also are in effect. This wasn't an object case, this was an effect case.
Absolutely.
So the violation is contingent upon the finding of effect.
Yes.
We're bound by the finding of violation.
Yes.
The real question is, to what extent does that drag in the finding of effect?
Well, for these purposes, effect doesn't matter, because no part of what we will be doing is disagreeing with the effect point. Because
Your exemptability,
yes.
isn't that part of it? You go through exemptability, that fails. You get a finding of effect, an effect restriction.
What you do with that's the end result,
Yes.
but effect is, you find, but when you analyse effect, you find there is a breach of Article 1011,
Yes.
and that's what the effect is. And I appreciate making points that are, but so you have the effect is, and that's what leads you to find Article 1011. That's the harm, and then potentially you can show that there are justifications.
Yes.
That's exemption. So, but we're not going to be disagreeing that there is an adverse effect on competition. So I'll show you possible at a sufficiently low level.
You would be seeking to establish exemptability factors which would have led, had they been accepted at the time, to no effects violation.
For a different EMF, a lower EMFs. So,
Not
should
the
we
same as the, well,
So, yeah. So, for these purposes, what I'm emphasising is by means of, so that is the wrong, this is what we've done is, and the definite article, the EEA MIFs. And we say, when you read that passage in its own terms, and in the context of the important starting point, that the Commission's role was to determine whether the notified EMFs were lawful or not, we say it's absolutely clear. The finding was about the actual EMFs notified, not all potential EMFs at all. It simply can't be, and I'll explain why. But if we now turn back to paragraph 133 of judgment, we can see where I respectfully say the tribunal went wrong in relation to this. And the tribunal sets out, quotes, that it's clear, it says, it's clear from Article 1 that the infringement comprised the MIF as a restriction by in effect setting a minimum price acquirers must pay to their banks for acquiring payment cards. It doesn't quote what I say is the important bit, which is by means of the inter-EA MIFs, which is critical because what they then go on to say that is the effect of any MIF. It's not dependent on any particular levels of MIF, which is why they're saying it is a more general finding. We say when you look at it in its context, it's quite clear it's a specific finding, which it has to be about our actual conduct. And that follows necessarily from the nature of what the Commission was doing in Article 1. It was making a finding of infringement. And in order for there to be infringement, it had to look at what we'd actually done. It can't have said, it wouldn't have been able to say, you would have infringed if you'd done something different. That's not what we'd done. You have to look at what we'd actually done and say that conduct was an infringement. So the Commission was not, and had no reason to, make any rulings about hypothetical different EMFs because we hadn't set them. As I've said, infringement is ultimately binary. Were the EMFs lawful or were they not? And with respect, the tribunal has focused on and quoted the words by in effect setting a minimum price without focusing on what I say are the critical words here, by means of the intra-EA fallback interchange fees. And that's why we say with respect, my learned friend's wrong to argue as she does in paragraph 55, skeleton, that Article 1, as she says, extends to any positive EMFs. It doesn't. Article 1 is necessarily a finding about MasterCard's actual conduct, and MasterCard's actual conduct infringed, and that's the actual EMFs. And when my learned friend addresses the actual words of Article 1, she very sensibly doesn't dispute that. She accepts at paragraph 62 of her skeleton that the finding of infringement was, of course, that MasterCard's notified EEMFs were not exempted. It's not quite that simple, it's infringed, but she's absolutely right to say the finding was that our notified EEMFs were unlawful, nothing else. We say there are further 3 problems with this paragraph of the tribunal's judgment. This is the critical paragraph on Article 1. And these are, firstly, having focused just on sort of the first part of Article 1 and not the critical words by means of the intra-EEA the tribunal states that the conclusion that MasterCard had restricted competition by in effect setting a minimum price merchants must pay to their marrying pack is the effect of any EEMF, so the Commission is not making a decision depending on any particular level of EEMF. And with respect, we say that is simply wrong. Firstly, it's wrong to say that that is necessarily the position in relation to any EEMF. The Court of Appeal, this court held in Sainsbury's, and that's at paragraph 174, and that's authorities tab 32, which I have in authorities bundle 3. But the point there was that the court held that it was open to a card scheme to contend that MIFs that were seen. Paragraph, it'll be page 1072 and 174. Turns out. And it's about 5 lines down. We accept that in theory, so this is a combined judgment of the court, including my Lord Chancellor. We accept that in theory, it could have been argued that the scheme's actual MIFs during the relevant periods were so low as to differentiate themselves from the legal position determined by the Court of Justice's decision. Plainly, the reasoning of the Court of Justice to which we referred does not mean that any very small default MIF would automatically be a restriction of competition. So there isn't a one-size-fits-all answer that says every MIF, regardless of how small, necessarily is a restriction of competition. There is certainly a point when that ceases to hold good, as the Court of Appeal has said that. So the point that the tribunal are making at 133, that the statement made about our actual EEMFs, which, and I'm not going to take the weary this court by taking them through the paragraphs, was the result of 400 recitals of detailed analysis of actual rates, actual what had happened in different markets, and evidence of the real world. That analysis based on effects, which is always about an analysis of the real world, not an objective infringement where it's done at a level of generality, simply isn't a general one-size-fits-all conclusion. There are limits that it goes on. So the starting point here is that the assertion that that is the effect of any MIF is simply wrong.
But as I understand the tribunal's judgment, they're saying you were obviously the Commission ruled on the actual notified MIFs, but you were told to take out of your regime, your rules, the entire provision that enabled you to charge any MIFs. Article 3, I mean, they refer to paragraph 133 of the Tribunal's judgment twice to paragraph 64 of their judgment, where they refer to Article 3 of the decision, which basically, and Article 3 of the decision says that within 6 months you just must take out your intra-EEA fallback interchange fee regime, full stop.
Well, if I may, my Lord, I'm absolutely alive to these points. What I'm doing at the moment is just going to take you through Article 1, and then I'll come back to Article 3, or not come back to, I'll come to Article 3 as the next point on this. So we say, in terms of the reasoning at the moment, that the situation that is the effect of any MIF, we say with respect that is simply, that has been established by this court not to be correct. The point we made below, the tribunal didn't deal with it. So that's point 1. The second point, even if it had been right as a matter of logic that any MIF would have had the restrictive effect, the Commission was not making any such general determination. It was addressing, we say, as is absolutely clear from the second part of the article, the position in relation to the actual MIFs on which it had hundreds of paragraphs of material as quoted in the recitals. So
I'm not certain the CAT really disagrees with you here. I mean, its point is slightly different. It was the decision which it's looking at, which binds it, proceeds upon the basis. Well, the CAT has to proceed upon the basis that damages are on the basis of an analysis of 1011 in the decision. The decision includes findings on exemption. The CAT isn't going to permit the parties to relitigate any component of law or fact going to the breach. You can look at loss and damage, but its starting point is that it's bound by those findings of breach. An exemption would just simply be one step on the way to a finding of breach, and all that's rigid, if you like. That's really the crux of the dispute between the parties. Is it absolutely rigid? Or does it mean you can relitigate parts of it?
well,
Does the CAT say we've got object, well, no finding but effect, which involves counterfactual, determination of relevant market, looking at the difference between actual and counterfactual, then we've got exemption, consumer benefits, technical benefits, indispensability, all rejected. Ergo, breach of 1011, we're stuck with that finding and everything that it carries with it in its trail, which is now rigid for us. That's really the issue, isn't it? You say no. I understood the CAT's decision really to be, yes, it is. It's immutable, can't change it.
yes, but I'm starting at the moment with 1 through 3, which is they're saying, you know, they're looking at it by reference to Article 1.
Yes.
So I'm starting with the prism of Article 1. But what I say in relation to that, as I said, obviously the operative part of the decision is binding and such necessary part of the reasoning behind it. What I'll show you when it
When
comes
you
to
say such necessary parts, that includes the finding on exemption. Well, of course, granted it is, you might have done something different, but it's there, it's in it. And that's rigid. And the question is it rigid for everything else, loss and damage? Or do you just simply start? That's the parameters. You know, and whatever those findings are, they set the parameters for the computation of damage.
well, what I say is, I mean, I'm not disagreeing with any of those findings, because what I'll come to show you is when we look at the articles, the recitals behind this, what they do is they say the first condition is not met in relation to the MasterCard.
Understood.
Yeah, so what we say is, absolutely, having had that finding, I can't go back and say, no, the first condition was met for MasterCard's EA MIF, actual MIFs.
But can you change the parameters for any other element of the tortious claim? And you say yes.
We say, you know, in any tortious claim, we rely upon the approach that was adopted by this court in Sainsbury's, that once you've said our actual conduct was unlawful in some way, we have, then the question is the counterfactual, what would have happened without that unlawful conduct, and you look at what we could lawfully have done. And I used perhaps a bad analogy of below of if I'm, you know, if there's a binding finding against me on speeding, obviously you still look at, you know, what speed limit was, how fast I could have travelled, and that doesn't itself, you know, and the same thing with the cartel.
You're absolutely right in principle. The question is whether, because you've been through a process which in a sense determines the counterfactual, are you then stuck with that? Or can you re-argue something which was in the decision which you lost on? What the level of the exemptable MIF was. You didn't put that,
Well,
it's not part of the analysis. You had your case, you were found guilty on that case. You now say, I want to change the parameters of what's in the Commission decision for the purpose of something separate, tortious. The question is, can the CAT allow you to do that?
Well, at some point I wouldn't accept that I'm changing the parameters of anything that's in the Commission decision. I'm accepting the Commission decision as it stands in relation to the thing that it decided about, the actual EA MIFs. What I'm doing is saying, fine, I appreciate, but you're putting the point to me.
I understand your point, and you're right in one sense, but the question is, can you? I mean, this is sort of, I think, what they're saying in 140, when your argument, you know you're on a hiding for nothing when they describe your arguments as skillful, don't you?
Well, that is always the bit.
It's a very bad start.
I've never won a case where I was skillful. Cases where I'm unskillful. So I'm happy if you describe it as unskillful if I win.
My recollection is, despite the ingenious submission, was always a prelude to being told you'd lost.
I think if you look at the earlier part of VTB in the Court of Appeal, you'll find that my submissions are repeatedly described as excellent, etc., until they get the boot right out of the ground at the end of the first part of the decision. So
It was far worse in the days of oral judgments, when you heard that word, and up until that point you didn't know where it was going, and when, you know, it was described as skillful submissions, you knew you didn't need to listen to the rest. But
is it in more simple, it's sort of, let's say, non-competition language? You're saying, look, the Commission basically decided on liability on what you did. You were speeding.
Yes.
But they weren't deciding the financial impact quantum damages.
Yes.
And this case is actually all about something the Commission didn't decide. And for the purpose of assessing damages, you ought to be able to say, well, actually we could have done it lawfully. That isn't contrary to any part of the Commission's decision.
apart from the fact, I wouldn't say could have done it, we could have done something.
Could have done something.
Different.
Yeah, we could have done something differently. And the Tribunal and the Commission just simply didn't engage with that possibility because it wasn't part of their remit. They were just looking at what you did and they said you was doing.
And absolutely, and that's my submissions come to, is the fundamental difference between what the Commission is doing. The Commission's role is a binary one, good or bad, is this conduct lawful or not, versus the difference of what the court does, the tribunal will be doing in a damages action, which, and I've given the example of the cartel case, which is always about saying, fine, we know there was a cartel, we know that was bad, what impact did that have, which is always then, what would prices have been absent?
This is
Here it's partly saying what we could lawfully have done that was different, and it might be, you know, a variety of changes, some of which are causation changes potentially. This one simply involves an element of 1013 as justifying it, but it's exactly the same point we say of that is the second that is the stage that, and it's the reason why you have so many cases in front of the CAT which are follow-on actions. There's still a great deal to be decided because in, for example, the trucks cases, it was decided that there was a cartel which impacted on prices. It's an object infringement. But the impact is never determined by the Commission because it doesn't need to. It just needs to decide there is an object infringement, doesn't need to decide at all. But even if it decides to consider it, all it needs to do is decide it has an appreciable impact. But appreciable could be 5%, 10%, 50%. That's always left to the damages court to decide. So that's what we're saying. This is all part of that second stage, which we are now in. And it's a necessary part of saying what would have happened in the counterfactual, how would it have evolved for those damages?
But the Commission's view was zero MIF was exemptable but nothing else.
Well, and that respect we say is that is not the Commission's decision, because the Commission's decision was Article 1. This EAMIF is an infringement.
But I think, you see, I think where the tribunal, sorry, where the CAT got to is saying, yes, we know Article 1 says, as it were, the MIFs that you actually said were unlawful. But they didn't say in Article 3, put in place some other MIFs that are lawful. They just said, take them all out.
I mean, the whole point of Article 3, which they refer to in the paragraph, cross-refer to at the end of 133 and sends you back to 64, is that tells you to effectively dismantle the whole structure. I mean, it doesn't preserve the right to, it doesn't say dismantle the whole structure, but you can come back and try again. It says dismantle the whole structure.
You see, because I see the court's interested in Article 3, so what I'll do is come on to that now.
The reason that
a couple more points on Article 1, but I'm very happy to come back to it.
The only reason for it is that it seems to me one has to read these. I mean, this is a dispositive part of the decision. You have to read the whole thing together. You can't just read Article 1 in isolation. You have to read it with the other articles, specifically Article 3.
And following that, but when we look at the CAT decision 133, which you were criticising, you criticised the CAT for the word any MIF, and you said that's wrong, it should have been the MIF. But the reason for that wording of the CAT is Article 3 of the Commission's decision, because that's what's referred to in paragraph 64 above. If you look at the sentence that is the effect of any MIF. It's not dependent on the particular level of MIF which MasterCard had notified. See paragraph 64 above. When you go back to paragraph 64, that's all to do with Article 3, which says take the whole regime down. And so I think that, to be fair to the cat's use of the expression any is taken from the fact that Article 3 of the Commission's decision doesn't say reduce your MIFs. It says just get rid of them.
Yes. Well, and so what I say in relation to Article 3 is Article 3 needs to be read alongside Recital 13. So I can show you that.
What I'm sort of putting to you, I think, is you wanted to try and sort of salami slice up the reasoning and sort of say it doesn't work if you just look at Article 1, but the cat's view is you've got to look at 1 and 3 together.
Of course you do. I mean, I'm not saying you don't look at it. I'm, showing you actually what the decision part of it is, which is Article 1. We'll agree that's the finding of infringement. Then we come to Article 3, and I say quite clear you have to read Article 3 alongside what is then being said in Recital 13.
If you'd have taken, instead of taking the course that your clients chose to take, which is not to put forward alternative MIFs at a lower level, but to go for broke, if I can put that right. Well, I'll use your words if you want me to go back in the transcript. I think you tried for better, I think was your words a little earlier. It failed. If you hadn't, your clients hadn't taken that decision, it would have been open to the Commission, wouldn't it, in Article 3 to say reduce your MIFs. They wouldn't have made Article 3, or you could have tried to persuade them that actually the decision in Article 3 would have been keep your regime in place at a different level.
And with respect, we say essentially that is what Recital 13 does, except recognising at that point we hadn't done the work. We then did the work over the next 18 months and reached a point. So I say that is important because it's easy to look at Article 3 and say that's saying get rid of the whole regime. However, it has to be read there alongside Article 13, Recital 13, which is page 1617. We look at that.
Can I just, before we go then, go back to Article 1, yes, you're quite right, it uses the definite article. But the pith and substance is that setting a minimum, in other words, any form of flaw, is a violation. So that's anything above 0 and is non-exemptable.
Well, with respect, I would say that is the effect of what we have done.
But that's their finding. Anything above 0, a flaw, in other words, price fixing of any description, is a violation. And that's anything above 0.
Well, with respect, I would say that is not what they've done. Is said the infringement is by means of the intra-A MIFs, and that has the effect of setting a minimum price. And that is, as I said, there are 400 recitals which analyse the actual EA MIFs and concludes based on the data, the numbers, pass-on rates, MSCs in different categories, a whole variety of quantitative analysis that's done to make that good in relation to these MIFs. Not, and not as we've seen, but that is true of every single MIF at all. Because there may be small levels where it's not true. So they have done, that analysis is in relation to these MIFs, and the finding is that the EA MIFs, the definite article MIFs, had that effect of setting a minimum price. Whereas different EA MIFs might not have had that effect, which is what the Court of Appeal said. But if we come back then to Recital 13, remedy, so this is explaining what is otherwise then in Article 3. So as MasterCard's MIF restricts price competition, the Commission orders MasterCard to withdraw its intra-EA MIFs within 6 months upon adoption of the decision, excludes one part. The order does not prevent MasterCard from adopting an entirely new MIF, other than the existing ones, that can clearly be proven to fulfil the 4 cumulative conditions of Article 81.3.
I mean, so it's not saying use the same regime but at a lower level. It's saying you've got to have a different regime.
Well, I'm not sure what you mean by regime here. Well, I mean, what we have in our rules is a permissive power to set,
Okay,
and none of that was ever changed.
you cannot
What happened was we simply used that power to set to 0 for a year-long period, and then we used that power to set to a rate the Commission accepted.
at page 1619, there is the definition of intra-EEA fallback interchange fee. Okay, that is the thing which you cannot adopt in the future, according to them. You cannot, I mean, that's, I'm just reading recital 13. You can adopt an entirely new myth, but not as defined the intra-EEA fallback interchange fee. So you just can't use that technique, that particular thing. At any level, that's what it says, isn't it?
Well, with respect to it does, I mean, I don't think it does. I mean, firstly, I was critical here in terms of, I mean, that's an accurate description generally of fallback interchange fees. The term that's actually used, I would say, is important, is 1620, which is the definition of MasterCard MIF. Is used reference to the organised network rules and the decisions of MasterCard that determine fallback interchange fees. The MasterCard MIF is the subject of this decision, which again is what I wanted to show the court, which confirms it's the actual definite article MIF, which is the subject of the decision.
But I'm picking, you're saying, you know, look, Article 1, it was unlawful. Article 3, the decision, dismantle the regime within 6 months for charging intra-EEA fallback interchange fees and CBE intra-Eurozone fallback interchange fees as defined in this document. You say, yes, but recital 13, and I'm just pointing out to you that recital 13 says it doesn't prevent you from adopting, and I propose the words for the future, an entirely new myth, something which is more broadly defined at page 1620, but the one thing you're told you can't do, in bracket, in the parentheses, in the brackets, is to use the regime you currently have for what is defined as an intra-EEA fallback interchange fee, or a CEPA, whatever, at any level.
I think the problem with this, and it may be for those who are sort of steeped in interchange fee litigation.
Yes, I'm sorry,
is,
coming from just a simple, humble sort of chancery lawyer.
No, I'm
sort of
saying,
saying, look at the definitions and just see what they say.
The other thing I just like,
what I was going to say in answer to that, so it wasn't meant to be as rude perhaps as it came across.
I'm just saying, part of the dismantling that's required by Article 3, it requires you to repeal all decisions effectively taken by management in relation to intra-EEA fallback interchange fees, etc., which seems to me to be directed at the whole regime. Imagine the situation, I don't know if this was the case, where there's within MasterCard there's been discussion about at what level to set the interchange fees, and a decision taken to set them at the level at which they were set, or a decision taken to increase them, for example. What Article 3 is saying is you've got to dismantle the whole thing back to square one, which must mean, it seems to me, that they go completely. It's not preserving an entitlement so far as the past is concerned to put in place some different level of fee, or to say, oh, well, we would have been able to justify that different level of fee. What you've referred us to in Article 13, or Recital 13, is looking at the future.
And I think you've got to read Recital 13 in the context of Recitals 2 and 4 as well, which makes the point that it's the MIF system. And in Recital 4 they refer to the fact that there are open systems which don't use a floor MIF at all, which operate. That's their counterfactual, which is a MIF system per se. In other words, you could have it, but it would have to be set at 0, which would be an irrelevance.
There are a number of points the court has put me there, and I will try and deal with all of them.
Sorry, ingenuity and skill.
Yeah, sorry.
Oh dear. I think the first point with Snowden was that essentially just reading the language, doesn't this mean we can't do sort of anything very simple? As a practical matter, sort of the only way to have an interchange fee, multilateral interchange fee, is there is a rule providing a power to do it, and then there is actually a decision to do so. So the new MIF that they are talking about in Recital 13 necessarily needs a power plus a decision to set it at a level. So it isn't, there isn't scope to there to be something of fundamentally different sort of nature other than being, it can be a different rate, it can be a different way it applies, different levels, but not that there is some, something that is so completely different. So it is just, we can adopt an entirely new MIF. That is going to be a decision that the MIF is this, but, and that's what happened, of course, in 2009. MasterCard didn't actually get rid of its power to do this. It just simply used it to set 0. That was fine. The Commission was happy with that. 0. And we then, following discussions with the Commission, took a decision that they were happy with to set at, as it happened, 0.3% credit. So, and that was just simply that then becomes a new rate. So there isn't some radically different way of doing this. It is simply what respect I say is that when you read Article 3 alongside with the permissive Recital 13, you have, and they're both forward-looking is the other thing. One says do it in 6 months, but the other one says, well, we're telling you to get rid of it. We're not saying that you can't potentially introduce something different. And I say, when you read the bit other than the, and again, definite articles, and of course the general definition of interchange fees is a more general one. Here we're talking about the intra-EA fallback interchange fees. So we can adopt, as long as it's not the same, it's opening the door to us to do it. But of course, provided we can justify it by reference to 1013 evidence. So I do say in relation to this, they're saying, of course, the Commission has made a positive decision, negative decision, that our actual EMIFs are unlawful. We must get rid of that. But it is also saying something different, see our previous decision practice, Visa, might well be acceptable. Provided you come forward with the evidence, you can do that. So we say the idea that you can draw a conclusion from this.
That cannot be for the past, can it? Because you can't undo the past by creating a new MIF. That can only logically say, well, in the future, theoretically, if you come up with a stonking good exemption case, we'll have a look at it. But why? That can't be retrospective. But they're not saying that you can change the analysis we've set out in this decision for the past.
But with respect, I'm not saying they do change the analysis in the Commission decision for the past, because the analysis of the Commission decision is about the actual EMIFs. So what I'm doing is showing that they are not making a blanket ruling that every EMIF necessarily is unlawful. They are saying, we found these EMIFs unlawful, you must get rid of them. They're acknowledging there's the potential for other lawful ones. For damages, I say that's a necessary part of it.
So let's put it in very simple terms. Let's assume that the MIF was 10, historically. And they're saying you haven't, prima facie it's a restriction to have anything above 0. You haven't established that 10 is exemptable. Maybe you can do in the future, but you're going to have to come up with some new evidence. So we're now stuck with the past. 10 is unlawful. You then want to go back and say that finding in the decision is now largely irrelevant because hypothetically, the decision should have been the relevant MIF is 2 or 3. And therefore we can compute damages by reference to 2 or 3 or 6 or 7. But why doesn't that undermine the decision that the cat's bound with?
I mean, a couple of points just in relation to that I'd address. Firstly, the Commission haven't said prima facie anything above 0 is unlawful. They haven't said that at all. They have said the EMIFs itself, based on lots of analysis of the actual numbers, are unlawful.
Isn't that the same thing? Going back to recitals 2 and 4 of the executive summary, any MIF. So that must be 0. Anything above 0.
Recitals 2 and 4
of the executive summary.
Where are we? Page?
Page 1615 of the decision.
That's the MIF in MasterCard.
Look at, well,
because all of
the
this
MIF
is
is
about the
unlawful
actual,
because it sets a floor.
and that is not a conclusion that I disagree with, or I can disagree with, in relation to this decision, which is about the actual MIF, analysed based on those figures and numbers extensively.
And 4, an open payment system such as MasterCard can operate without a MIF. So without a MIF, any MIF. And that the starting point was you don't need a MIF. And it must follow therefore that anything above 0 is prima facie within 1011, subject to exemption.
Which, subject to the point that the Court of Appeal made, and I've shown you in Sainsbury's, I wouldn't disagree with, and that's essentially where we get to with the Court of Justice's reasoning and Sainsbury's and the Supreme Court. But nonetheless, I mean, what I'm now doing is not trying to go back and argue restriction. What I'm doing is saying, fine, I'll take it on the chin that the logic and reasoning of this, not least because of Sainsbury's in this court and the Supreme Court, is I'm not going to turn up and say, here's a small whiff, it's not a restriction. I'm saying, fine, accept it's a restriction. However, it would have been exemptable for these benefits. So that offsets those benefits.
It may boil down to a construction of the decision. The decision that the tribunal's bound with is that a myth, per se, is a restriction, and that's what they found. And that's because you didn't justify at the time anything above 0. The existence of a myth wasn't justified on the facts. And that's the finding of a restriction, which the tribunal's bound by. So it does come down to almost a conceptual question: to what extent can you, for the purpose of the next stage, loss and damage, reopen that question?
On that one, I would agree it does boil down to a construction of the decision, absolutely. That's what I'm trying to address the court in relation to. So you say that then the tribunal is bound to say a myth per se is a restriction. I'd say the Commission has not made any finding to that effect. And I was going to take you to the paragraphs in relation to restriction of competition. And those are recitals 663 to 5, which are page 1793.
I'm sorry, just before you do, because I mean, I'm still trying to play catch up here in sort of... I read Article 1 as saying you were speeding, right,
yes.
You breached. Article 3 says you've basically got to dismantle the architecture that you have currently. In other words, sell your car. It'll take you 6 months to do it. That's all, we're given some time. But you've basically got to dismantle the entire architecture, i.e. repeal the rules, repeal the decisions, just take away the whole structure. It's not a question of allowing you to set a lower MIF within the existing architecture, just say bin it. You didn't ask for any ruling about a lower MIF, so they said, fine. What you've done is unlawful, get rid of the architecture. What you are permitted to do, admittedly it seems in the summary, although I'm not entirely sure I've managed to find it in the actual recitals.
Well, it is the recital.
Yes, I know, but you can trace the other parts of the executive summary, to the recitals.
Yeah,
I'm not sure I can get to the other recitals.
Yeah.
You know, so that actually the remedy recitals start at page 1816. You know, and they talk about, you know, what you need to do and how long you've got to do it and all that sort of thing. I'm not sure I can find the equivalent sentence at the moment for which...
You're right to say it, you haven't found it because it's not there.
Right, okay.
Recital 13
I didn't know.
is the
Okay.
right one.
So what recital 13 is, what recital 13 in the executive summary is not actually reflected in the body, but putting it aside for a second. What it's saying is you can put in place a new architecture for a myth, a more generally defined term. But you can't use those things which are defined as the intra-EA fallback interchange fee and the CBE intra-Eurozone fallback interchange fee. You haven't asked for permission to do that. You haven't suggested you might want to use that existing architecture but at a lower level. That's no part of it. You haven't asked. So they just say, just bin it. If you want to bring in new architecture, new rules, take new decisions for the future, then you may be permitted to do so, provided you can satisfy the cumulative conditions in Article 81.3. But that's not anything under the current architecture. That's how I've read this decision. Now, if you're saying that in practice that's not the way it works, that in practice they would allow you to use the current architecture but just setting a lower fee, that at the moment doesn't leap out of the page at me. And
The one thing they don't say anywhere, either in Articles 1 to 5, because it's all 1 to 5, or Recital 13, is that you're entitled to adopt an entirely new myth, which, if it is at a particular level, will be exempt. I mean, they're just leaving it open because if you did opt, and we know you did in 2009, but they're not tying themselves, committing themselves to saying, well, if you had set the MIF at X, it would have been exempt. I mean, that's the one thing that doesn't come out of this at all. And when they go on later in the, I think, not long after this, fairly early on in their chronological run, they talk about the visa setup. And of course, the visa setup was actually a sort of temporary fix, wasn't it? It was for 5 years, from 2002 to 2007. And after December 2007, I think it too changed from recollection.
So again, if I could just...
And at that point in their decision, they don't say either, well, of course, if MasterCard had adopted the same approach as Visa, they would have been setting MIFs which were exempt.
So again, I think there are two sets of questions there. I'll address if I may, my Lord the Chancellor's first, and then come back to Justice Lewison's in a moment. But just to make sure, or Justice Snowden, sorry. My Lord the Chancellor, I think, was putting the point to me, the Commission has not made a positive finding that if we had done something else historically, it would have been lawful. He's absolutely right. You're absolutely right, my Lord. That is not the case. No. Of course, the reason why was that is no part of the Commission's role. That is a case, that's the distinction I was drawing between the Commission's role to decide whether we have our actual conduct lawful or not, versus the role of a court in damages to decide, fine, there's an infringement, what was its impact, which looks at what would have happened without that. So they didn't decide that point because it's no necessary part of deciding whether the alternative lawful had been 0.3%, 0.5, 0.7 as opposed to our actual 1%, the 1% is still unlawful. So they don't need to consider putative unlawful alternatives. The only question for them is, what was the actual? Was it lawful or not? And their answer, I'm not getting away from, is that is the actual one was unlawful. So you're right to say, my Lord, that they didn't address it, but that's just simply because that's no part of their remit to address the alternative. So I say that doesn't take us anywhere. I may then come back to, my Lord Justice Snowden's, the question you were putting to me, which is, I started it, the car analogy, that I've been told, I was speeding, I must get rid of my car. And to some extent, what they've said is, you must get rid of that car, but you can buy a new car, provided it meets criteria of a certain kind that I need to establish. But it comes a point where, I'm still allowed to buy a car if I can meet those criteria. So the distinction is
not one that works in the same way as the old one.
Except it is impossible in this world to envisage a mechanism of doing this that is, any real difference. These cases have always been about the rate. Once it's multilateral, it's about,
that's curiosity, because I think what you're saying is you need the same architecture, and it's just a lower rate. And I'm just trying to give some meaning to this Recital 13 that doesn't appear anywhere else in the document, but just is there in 13, where it says you can have an entirely new MIF other than, as it were, the EA fallback interchange fees pursuant to the infrastructure that the remedy that's been granted against you tells you to dismantle within 6 months.
I mean, technically, of course, what we could have done is repealed the rule, which was a permissive rule allowing us to set EA MIFs and then reintroduced it 6 months later. But certainly in competition law terms, looking at the substance, it is always going to be substantially the same, the architecture which allows us to set these things. But just because any set of rules that gives us the ability to do so, and us is, it's an associative undertaking, so it's not relevant which person does it or which committee does it, which again is one of the reasons they rejected our points about association of undertakings. So there's always going to be some kind of power to do it, and then an execution of that power that actually imposes it. So I do say that as a practical matter, just recognising the commercial reality of these things, but what we've been told is we can set a new lower rate in the future, provided we can satisfy them that it meets the criteria.
I'm just wondering if that's correct. You were going to take us to I think it was 663, the conclusion on 81.1. And I was just looking at that and looking at the definition of that which they held was the restriction. That which they held was the restriction was something called the MASTERCARD NIF. And that's defined as the rules and any decision implementing the rules. And the decision, which is the MASTERCARD NIF, is found to be in 664 a restriction because it sets a floor. In other words, any minimum, any MIF at all. And in the absence of the interchange fee, in other words, anything set under the rules, rates would be lower. So the way in which the restriction or the decision of an association of undertakings and the restriction is cast is not a level of MIF, it is the very existence of any MIF. And that comes from the definition in 663 and the definition which is on page 9 of the decision of a MASTERCARD MIF.
Yeah.
It is the rules in themselves.
That's why the rules have to be repealed.
That's why that really explains Article 3. It is the system of any minimum floor price, because once you set that, you restrict competition below it. And that rather explains, I think, why you've got paragraph 4 of the summary, the executive summary, which refers to lots of other systems not having any MIF at all. Open systems.
That was meeting an objective necessity style argument, but so that they did point to the fact that there are others that exist without it. But so in relation to this, we go back to the various points that were put to me.
Well, why don't you have a think about this? Because I think we ought to have a break, really. So we'll break now for, I'll say 15 minutes. I don't think we're in any danger of not finishing today, are we? No. Okay. So we'll come back just before 25 to the MAC clock.
Court rise, if able. I would just like to inform the court the recording is still going on, so if you need to talk about something sensitive, I would suggest you step outside.
Okay. Feels like the biggest nightmare is
But we need to be back. I need to be quite busy.
I'm just going to get to
Well, thank you very much. Cheers. Thanks, Joshua. Not to the bench. Sorry, There's water gone too.
What's that?
There's water gone down with the cold too.
Terrible. It's like it feels like a triangulation.
I'm really sorry.
No, it's not before, I'm joking. Have you got one of those throat sweets? Because I really feel my throat's getting scratchy.
Got loads. Yeah, I've got another pack.
That's great.
No worries. So I was trying to not stop coughing.
No, don't worry about that.
Found you a Brunello jacket.
What have I what? Have you?
Brunello jacket. Beautiful.
Can you show me?
Yeah, well, it's absolutely beautiful. It's in white. It's absolutely beautiful.
Can be productive.
Productive afternoon. It's very nice. Kid is surprised.
Show me.
It's nice. Should go into that. These would be nice for you.
I should look at this.
Look, well, that's nice.
That's really nice.
Yeah, it was too good. It's too bit too long for me.
It's really nice. That is really nice.
Yeah,
Yes.
look.
That's hot.
No? What do you?
Just like it's the distribution. That cool. Oh, is that it? It's so nice.
Isn't that beautiful?
Love it.
Yeah, beautiful. Look, and it's got trousers that you can carry it
I love
back
it.
on.
Oh my god, that's so nice. That's so nice. Right, I'm gonna look. God, you're so good at this. You really are.
I really am. I've got real talent brain. Just no one pays you. It was my dream. I spent years trying to persuade the best mate to open up a gift shop with me.
That's so nice. I love that. Honestly, that is really excellent.
What's that?
What have you found for yourselves?
Nothing yet. Disappointingly. Anyway, that's what I'm fine. So pretty. These are jeans. These are such a nice. They would go with it. Thank you.
All of the cliches.
I think it's called normal. She lives in Essex. They are both registrars of Cambridge. Do you think I should? Rebellious is the common saying. Is your family shipping?
No. No, my dad's the civil engineer.
Court rise, if able.
Okay, my lords.
Yes.
The paragraph I was going to try and take next, I think that was the crux of Lord Justice Green's question, was the definition of the MasterCard NIF.
Yes.
It's fair to say a lot of what my submissions are on these points, going back to, I say, the constant use of the definite article, the MasterCard NIF, the interchange fees, matters like that. And we find the definition of the MasterCard NIF at page 1620, I believe.
Well, it's actually a definition of MasterCard without the definite article in the heading, and then later on it uses the definite article. So I'm not sure how much one can read into use or non-use of definite article.
Well, one of the first points I was going to make by reference to this is this then does consistently use definite articles within this. So the point that's being put to me is MasterCard NIF there is used as a reference to the organisation's network.
Actually, that's not, with respect, I don't think that's actually right. If you just look at 663 and 662, you can just see that it doesn't use the definite article in 662.
I'm going to come back to those paragraphs. I'm going to start with the definition of MasterCard NIF, and I'll show you where I say this goes. So, definition of MasterCard NIF is used as a reference to the organisation's network rules and the decisions of MasterCard that determine the intra-aid fallback interchange fees and the separate interchange fees. And then at the end of that, the MasterCard NIF is the subject of this decision. So what I say in relation to that is, yes, it is right to say it's defined as including both the rules, MasterCard's network rules, and the decisions of various MasterCard entities that made decisions about the exact level of the intra-EA fallback interchange fees. Yes, it's right, it is A plus B, rules plus the specific decisions setting particular rates at particular levels.
And they emphasise that, don't they, with a bit of a italicisation.
It's and, yes.
And.
Yes.
And.
Well,
Yeah.
I mean, there are reasons of that we probably don't need to worry. Not reasons for the italicisation, perhaps, but it's the fact that they talk then about it's based on commonly agreed. So this was about the Association of Undertakings point. Some of the rules originated from when MasterCard was owned by the members. But yes, but it's nonetheless, MasterCard NIF is defined as A plus B, rules plus the decisions setting the intra-EA MIFs. So I don't shy away from the fact that it's both, but I do then say that, I say that is a definition that is specific to the actual interchange fees, the actual decisions that set them. And then if we go to 663, the MasterCard NIF, so that's 1793, Con's decision of an association of undertakings, both before and after that decision. So again, I'd say, and I'll move on to the rest of this, but the starting point is said the rules plus the specific decisions, A and B together, Con's decision of an association of undertakings, the rules plus the actual decisions restricts competition between acquiring banks by inflating, but again, that is based on the decision setting the interchange fees. In the absence of the multilateral interchange fee, which is what we're just talking about, the prices set by acquiring banks will be lower. And you cannot look at 664 in isolation of what I won't bore you by taking you through, but it's very much there. But we're on recital 664 because the Commission has just spent 400 recitals, plus doing other bits, but 400 recitals making good the analysis by reference to this interchange fee that shows that this interchange fee does have that particular effect, that it was having an impact on prices and showing how it works. So there is specific evidence analysing this set of decisions and this set of interchange fees.
665.
And then 665, the MasterCard NIF is not objectively necessary.
That's the rules and any implementation thereof.
Decisions.
Well, it's not, but it's the MasterCard NIF is defined as the rules plus these specific set of decisions is not objectively necessary. Because with all of these sort of attempts to justify, you'd always be looking at the combined ones. So, this is not saying, there's no part of this saying the rule is an intrinsically a restriction. It is A plus B. Rules plus these decisions together are a restriction, as you say.
You say that the definition is the rules plus the decisions, brackets, in particular at the levels at which they were set, close brackets.
Well,
How does that
16,
square
20.
with 665, which is MIF is not objectively necessary because the counterfactual is open card systems without a MIF, in other words, any MIF.
So the first thing, if you just go back to 1620, which is the definition point. So the definition point, I do say in relation to that, that is, it's the decisions that determine the in-tree A4 baggage change fee. So that is talking about the specific decisions that these specific fees that were notified were being analysed and considered by reference to hundreds of paragraphs of evidence about those fees, those rules, how they operated, and which were then found the rules plus those decisions plus those fees was then ruled to be the infringement. If we then go back
Well, it's
to
because they were dealing with the intra-EA MIFs.
yes,
They weren't dealing with all the other MIFs
oh, right.
in this decision.
Yes,
They dealt
absolutely.
with other MIFs in other decisions. It would be helpful, I think, to have the unredacted version without business secret 2A, frankly, because we're told earlier in this business secret 2A, information pertaining to MasterCard's interchange fee rules and procedure for determining the level of the interchange fee. Now, that may or may not be of any relevance to the issues we've got to decide. Somebody could produce that by 2 o'clock, that'd be good.
We'll certainly do
Actually,
that.
business secret 2A, I think, is applicable to every definition. It would probably be useful to have all the definitions in unredacted form.
Well, I think in general we should get you the entire decision unredacted. It's unfortunate it is like this.
Well, can you just
to subset, I'd say it doesn't matter because in competition law, the minutiae of who, which committee, which official within MasterCard set it, it's all within the umbrella of what was found to be an association of undertakings. And no one was saying, oh, it was set by our chief financial officer, not our CEO. Gosh, that's the answer. So,
But the crux of the point is, you say that read in context, 662, 63 and 64 are about the rules and the MIFs as set, whereas 665 is generic and it's about any MIF system at all, because the counterfactual is banking systems without MIFs, open systems, which rather casts out upon the suggestion that we construe 663 and 664 as referring to very specific MIFs.
in answer to that, what I would say is, firstly, 663 and 664, I would say, on the wording are clearly talking about, particularly read in context of all the analysis which has done to those findings, that the MasterCard MIF, which I say is the specific interchange fees, the answer, MasterCard raised the ancillary restraint objective necessity point that we need MIF. And the answer to that, the Commission said, was, no you don't. There are examples of schemes which work without a MIF at all. But with respect to that might mean if I try to run an objective necessity argument, you would say that the inherent reasoning here was wider, but it doesn't make every part of this wider. Most it is in relation to that one argument where it could point to a zero MIF example and say that had no problem. So that was the answer to that point. It doesn't alter the fact 663, 664 and the finding of 1011 restriction concerned rules plus the specific decisions about the specific MIFs.
So why did they require you, in order to remedy the restriction of competition, to take apart the entire MIF infrastructure? Why didn't they just say, set the MIFs for the future at lower levels?
Well, 2 points on that. I was going to firstly come back to Article 13, that very much goes to this specific point. Recital 13, which goes to this specific point.
I'm looking at Recital 759.
I can do with Recital 13 first, and then I'll come to 759 if that's acceptable.
Yes, I mean, obviously, to the extent that 13 is just an executive summary of what is in the actual body, then fine, but the actual body includes 759.
It does. 13 is in the actual body in the sense that it is recital 13 of the decision. It is not some independent document. When you come to what you might be thinking of as the actual body, that of course is recital 15.
Yeah, no, it says, quote, executive summary.
Yes. But nonetheless, this is the...
But okay, it doesn't, we're not necessarily get hung up on 13 and 759, but I mean, the simple point is, if they thought that actually there's nothing wrong with the system, it was just the level that you'd set, which is the counterfactual you want to put forward in these current proceedings in this tribunal. Why did they require you to dismantle the entire regime and cease and desist from setting myths? I mean, basically, if you read this, it reads as if you shouldn't, for the future, be setting myths at all. Take apart your infrastructure and let the acquiring and issuing banks set BIFs between themselves on a bilateral basis, bilateral exchange fees.
Well, they're not certainly saying it should be done bilaterally. It's something that the Commission is there is detailed reasoning where the Commission rejects the idea of bilateral exchange fees as being a realistic possibility. But my Lord, if I can just go back to recital 13, then I'll come to the one you'd like me to come to.
Right.
What recital 13, which is perhaps in broader terms, but it says, as MasterCard's MIF restricts price competition, the Commission orders MasterCard to withdraw its intra-EA, so for interchange fee, fallback interchange fees. So again, it's the specific that we're told to withdraw, and then it says, having said we must withdraw our existing EA MIFs, the order does not prevent MasterCard from adopting an entirely new MIF other than, I would say essentially, the existing ones that can clearly be proven to fulfill the conditions. So the paragraph that's giving us the permission's the wrong word, opening the door to us doing it in the future, if we can meet the criteria, is distinguishing between you must get rid of the existing, but you can introduce new ones. New multilateral interchange fees. So it's not with respect to saying, my Lord, you must now go to a system where you cannot have multilateral interchange fees at all. It says, no, it's open to you to adopt an entirely new MIF, but that's still a multilateral interchange fee set collectively, provided it meets the criteria for exemption. It hasn't gone down the do it bilaterally.
So in other words, you're saying that the decision does not require you to cease and desist from determining the minimum price merchants must pay for accepting payment cards by way of intra-EEA fallback interchange fees.
I'm saying what it actually said was we had to get to withdraw, and that's Recital 13 says, withdraw our existing EEA MIFs. We could, had we managed to do it fast enough, a week later have set new EEA MIFs, and if the Commission had been happy with it, there would have been a point where we would never have had a period when we had no interchange, no EEA MIFs.
So you're saying the reading of this is that the Commission wasn't saying you must cease setting MIFs, intra-EEA fallback interchange fees. You've just got to do it at a different level. I do want you to come to 759 because I've just been reading 759.
No, and absolutely will now, my Lord.
And 770 in due course.
770. Yes. But before I do, the answer to what the Commission was telling us to do, the Commission was telling us this was an infringement, stop it. And it's what's clear from Recital 13 is it's not just saying set them at a lower level. It's saying if you're going to set them, we're open to the fact you might, but you're going to need to come along with proper evidence to show they're legitimate. So it wasn't preemptively saying now reduce them by 25%. It was saying come with the evidence and you can do that. But
So
yes, it was opening the door
saying-
to us just changing the level.
So
That's exactly what we did.
you are saying the Commission was giving you the green light to set a minimum price that merchants should have to pay for accepting payment cards, just not the current minimum price.
Well, that is essentially what I mean, insofar as any MIF, subject to the points I've made about any MIF would not necessarily have that effect, but the logic of the reasoning is that most MIFs will certainly have that effect, and they were opening the door to us introducing a MIF which, yes, would have that effect, so it would be a breach of Article 1011, but would nonetheless be lawful because it would meet the conditions for exemption under 1013. So they were opening the door to us having, as they say, a new MIF, entirely new. I don't think it's a new MIF. It mustn't be the same as the existing ones, provided we can now put forward the evidence.
Right.
And then, so you wanted to go, then we go to 759.
Yeah.
I mean, just but the point I was putting to you, I was trying to put to you, just plain reading. It says cease and desist from determining a minimum price. Any minimum price. You know, it doesn't say, you know, cease and desist from determining the current minimum price. You know, just come back with another one. It just says cease and desist from determining in effect a minimum price. End of story. Accordingly, 761. Accordingly, modify your network rules and repeal all relevant decisions with respect to the fallback interchange fees, etc., etc. I mean, it's just not. It just doesn't leap out of the page at you that what it's saying is don't worry about your architecture. It's all fine. Just come back with a different number.
I agree. If you were reading 759 and 761 without any part of Article, if Article 13 wasn't, sorry, Recital 13 wasn't here,
Which is why I keep banging on about the point that Recital 13 is in a section headed Executive Summary. I normally, when you see Executive Summary, it's normally a summary of
Yes.
what's in the rest of the body for people who don't have the time to read all the stuff and just want to cut to an executive summary.
Well,
But
you're absolutely right. Obviously, we're not the draftsman of the decision. To some extent, you might say that actually what's in the executive summary is often, as you say, the most important points.
well,
So,
no, it's
yeah,
just,
so
just for
these-
people who can't be bothered to read the whole lot. But yeah,
well, yes, but if you can't be bothered to read the whole point, it's still people try and identify what are the most important points coming out of something.
But are we right in assuming that sentence in Recital 13 about the entitlement to come along with a new MIF, an entirely new MIF, isn't actually replicated anywhere else in the decision?
That is where it is contained in Recital 13.
Yeah, it's not, that's my lord's point about it being in an executive summary. They don't return to that point anywhere else in the whole decision.
That is right to say. With respect, I would say exactly where it chooses to go in the decision is less important than the fact they put it in there. And they put it in a section which I would say, you know, ideally, that's something one sees all too often sometimes, that actually the executive summary gets drafted in a way which doesn't always perfectly reflect what's in the main body. But you know, it is put in there. The executive summary is some of the most important points. So it is the fact that they've chosen to specifically caveat. As you said, if you look at this without that, you'd be saying we must get rid of everything. But they've gone out of their way to specifically say, but actually we are saying, while we told you to repeal it, you can put forward a new multilateral interchange.
if you were just putting forward a different level of MIF, you wouldn't need to modify the rules, would you? You just, because I don't, do the rules actually contain the number?
It depends where one goes within. I think I'm at the level of trying to give evidence. There is a permissive rule, and there are previous decisions that talk about it. It's a permissive rule that says which you can set interchange fees.
And then
There
that's
is then a
done,
decision,
and then that's done by decisions by the chief executive or
and
whoever,
then there's
whatever.
often a schedule to the rules which reflects the actual numbers,
Yeah.
so that people can
So-
see them.
So you wouldn't need to modify your network rules if all you were, if what you were permitted to do was just to come back with a different number. You wouldn't modify the rules, you just have a different decision. And yet the whole ethos of the timing of this order and the actual remedy that was granted in Article 3 is modify your rules. I mean, that's why you got 6 months. I mean,
And that's picked up by Recital 762. Sufficient time to modify its rules or it doesn't take about 6 months.
I mean, if so, as you say, the rules, I entirely would understand the rules would be permissive and just would be saying, this is the infrastructure, this is the architecture. The actual decision on the number will be taken by business secret too, i.e. the global board delegate, the president and CEO of MASTERCARD Incorporated and/or his designee, the chief operating officer, or other persons in the association. I'm just reading out from what we now see in Article 3. They would be the ones who would set the number from time to time. But you wouldn't be required to modify your network rules if all you were doing, if what they were envisaging was just those people would just reach a different decision on a number that would be exemptable.
Well, except, I mean, as a practical matter, they're not just saying reach a different decision. They're saying you need to come along with a whole lot of evidence to satisfy us that the number you've reached is justifiable and meets the criteria.
No, they're saying in your entire infrastructure. Because one thing you can't come back with is something that is, even under Recital 13, the one thing you cannot come back with is a intra-EEA fallback interchange fee or a SEPA intra-Eurozone fallback interchange fee. What Recital 13 says.
Well, with respect, I would say that's wrong. It says other than, having said MasterCard must withdraw its intra-EA fallback interchange fees, we can adopt an entirely new myth other than the intra-EA fallback interchange fee. So again, it's talking about you can't just do the same thing. Obviously you can't. But, I mean, the point being is it's difficult to see what there could be that is different from an entirely new myth that is not simply, it's going to be a multilateral interchange fee. There are points about structure. Is it going to be ad valorem or is it going to be pence per transaction? None of that is of significance for these purposes. The only way an entirely new myth is going to be new is because it is at a different rate, different level. So that is the distinction. So yes, they may be saying sweep this away unless you can come up with something new. And to some extent, they're saying that this process has been going on a while and we haven't done it. So they may be perfectly happy that we never do it. Well, they are perfectly happy we never do it. It's for us to do it positively. But they have opened the door by Article 13 to saying we can come back with something new, not completely different architecture, because it's not impossible to see how they can be completely different architecture. It's just cannot be the same rates, but it needs to be justified. So we do say in relation to Article 13 again, is get rid of the existing, and you can come back with new, as long as it's not the same as the existing, and you have to justify.
Can I just put this into a legal context? In a decision based on effect, the one thing the Commission can't say is that we preclude the possibility altogether in law that you come back with something which is exemptable. If they'd said it was a restriction by object, they may have said there's absolutely no way in the future we can ever grant exemption to this. But in an effects-based decision, theoretically, there is the possibility of coming back and you having a better exemption case. But I mean, that's just the theoretical possibility. When you look at the remedies, I was looking at 770 because what it was saying was the scope of the decision was about the MasterCard arrangements. And they then made clear that bilateral agreements were not covered, and also national arrangements were not covered, simply because they weren't. But they pointed out the national arrangements were subject, at least in some member states, to national enforcement. But it's the arrangement they're basically saying is the subject of this decision. I don't think theoretically they can preclude the possibility that you come back with a new MIF and they'd have to look at it again, because this isn't an object case. I mean, maybe that's all they're saying in Recital 13. But the gist of the decision is it's the setting of any flaw whatsoever is a restriction and nobody's justified it.
Well, so the distinction on that is, one, of course, is the decision-making practice. It might be a difference between a case when the Commission is basically looking at it and saying, well, frankly, it's impossible. No one's ever going to justify this. We can't rule it out as being impossible, but it just doesn't seem there's any realistic prospect. Versus this case, where they had granted an exemption for EMIFs to visa for the 5 years covered by the decision at rates that were materially lower, 30% lower, but not of a different ilk in some kind of way. So I think I would say there is a difference in a world where the Commission is largely saying, you know in the past we've exempted these, so you know the kind of things that make us happy, and you can come back, as long as you come back with the evidence in the future, you can do it. So I think that there is a distinction. It might analytically be right to say that you could never make rule, say it could never happen again.
Once you've construed this decision, and we're arguing about its scope and effect, then the question is, what is its impact on the tribunal? And to what extent can you then advance evidential matters which may be said to be inconsistent? Now, if it were absolutely plain and there was a list of rates which were held to be unlawful, that may be one thing. If the decision properly interpreted prohibits anything above 0, because you can't have a floor at all, by definition means something above 0, then what is the effect on the tribunal of the decision? To what extent did Parliament, when it said, tribunal, you're bound, section 58A, by the decision, what does that mean? Is statutory res judicata in section 58? You're suggesting that however you construe it, you can reopen the Commission's findings because you want to advance a case which was not in front of the decision and a case which the Commission rejected because they said anything above 0. So you're saying, hypothetical 10 for the MIF, it could be 9.9 or even 10.1. You want to run that argument, theoretically. It could be anything, higher, lower, but you'll minimise the loss because you'll shrink the difference. But that is inconsistent with the decision because the decision is based upon 0, minimum, nothing above 0. So what is, in a sense, what is the legal effect of the statutory provision which bars the cat from opening up the decision? It's stuck with what's there. How do you get round that?
Well, the first point is a fundamental one, it's a matter of construction. If you do decide, you have decided that the Commission has found nothing above 0 is lawful, I couldn't get around that. With respect, I say
your fundamental point is that that's not what the Commission decided.
Absolutely.
We've got that.
I'm just saying, so it was put to me on that terms.
Yeah.
So, but I'm acknowledging if the finding is in it was that MasterCard, any myth, myths in general, we've told people lots of times before. Okay. That might be the position they'd adopt now and say, we've told people lots of times before, myths are bad, stop it. All myths are unlawful. Had Article 1 said that, of course, this is hopeless. We wouldn't be running these points at all.
They're not necessarily inconsistent with it, because you could have a position, this is what they've said, but because theoretically anybody's entitled to come back and put another case properly based on evidence, they may have to say, well, last time we found this, we've now got a case with absolutely compelling economic, technical, consumer-based evidence that a MIF set at 1.8 is exemptable. So you would still say, even if we said that this was construed as anything above 0 is bad, or would you?
I think I would essentially say I'm not arguing those kind of points because I think I might be able to argue them. I don't really have views on whether I could or not. I'm saying my attack here and the challenge is about the question of the construction. So I'm not saying if the tribunal is right that this is a construction in which the Commission found, as it's been put to me, that anything above 0 is inherently unlawful. I'm not trying to say, well, nonetheless we can have a go at it. I'm saying properly construed, particularly seen in Article 1, the decision is these ones are unlawful. You have failed to show the conditions of exemption are met in relation to these myths.
That's very helpful.
Yeah.
Right.
So, but that is the basis of it. So, and I said as well that I would, so going back to the point, I say Article 1 absolutely clear, properly understood. It's about, and every time one gets it, all the points are about the MasterCard MIF, which is a specific decision, so I say, open the door to a new MIF. We also relied upon, it's paragraph 73 of the decision, just multiple recitals, sort of all of the critical ones, which is the analytical framework which lies behind that ruling, which I say is the actual EE MIFs are unlawful. And each time is, as you would expect, an analysis of the actual EE MIFs on issues like appreciability. Because if it was 0.01%, it wouldn't probably be appreciable.
Sorry,
all these points.
You say we also arrive on paragraph 73
Of our skeleton, that's it. So it's paragraph 73 of our skeleton.
Sorry.
Sets out a whole host of dozens of individual recitals that we put to the tribunal alone, showing that each time the ruling is, and to some extent this is, firstly, it's not my learned friend doesn't disagree that the analysis here, fortunately, is that it's, she says in paragraph 63 of her skeleton, the decision necessarily refers to MasterCard's EMIFs, the actual ones we're looking at. So that's all the analysis. Each time it talks about the MasterCard MIF, the interchange fees, I say, in relation to that, it says what it means, consistent with the Commission's role, deciding on the actuality, not a hypothetical alternative. And when you do understand them in that context, there isn't a blanket ruling saying, because the Commission wasn't in a position, frankly, to rule on whether 10 basis points would have been lawful, 30, 40, 50. All it had to do was look at the reality, which was 100 basis points.
Now, in your paragraph 73 of your skeleton, you include the reference to, you include 759 as one of the recitals you refer to, and I do struggle to see how 759 supports the proposition you make in the first few lines of your paragraph 73 of your skeleton.
If that's the case, my lord, then that one maybe isn't the best point in relation to that. I do say 759 read in alongside.
I think we
recital
probably
13.
covered that ground sufficiently.
We've been over these points. Just in relation to, well, I was going to quickly take the tribunal, court through. I'm going to go 3 below and 3 above.
Too much time spent in the cat, Mr.
Court. What I was briefly just going to go through is the paragraphs from the exemption reasoning that are referred to in the judgment.
Right.
Can I ask you a point of principle? Let's assume there's lots of paragraphs in the decision which refer to specific MIFs. Do they not have to address that in order to come to the conclusion that a MIF is bad? I mean, the mere fact that they analyse a particular MIF doesn't necessarily indicate that the entire decision is about a particular level of MIF. One's got to go to the key analytical paragraphs where they draw everything together and come to a conclusion about what it is that's a restriction of competition that's exemptable. I mean, do you accept in principle that has to be right, or do you say that the fact that they're analysing actual MIFs is critical and proves your point definitively?
It is not impossible to imagine a situation in which somebody said, this is my analysis of actual MIFs. I consider, for economic theory, whatever reason, that analysis of the actual MIFs is applicable more widely, and therefore I conclude. But there would need to be that segue from the specific shows this, and I therefore draw a generality. And so intellectually it's possible, it is simply not present in this decision.
It comes down to your analysis of 662 through to 665. I mean, if you're right and that is really just a reflection of actuals, fine. If you're wrong, then they have segued from actuals into basic principle.
Well, if there was a point where they'd, I'd show you the paragraphs, if I thought there was something that did that, and then my learned friend will show you if she thinks there's something that does that. So it doesn't segue at any point into saying, and we can draw the inference from this specific that all MIFs are bad. It analyses the specific and then says, the MasterCard MIF, you've had my submissions on that, is bad. Now, some of that reasoning may be directly applicable. I'm not running a restriction case here to another MIF.
But 665 was addressing, wasn't it, the argument that had been addressed to them that you had to have a MIF to operate a card system. And that was an argument that was repeated in Sainsbury's and MasterCard, or Sainsbury's and Visa, and I think also MasterCard. It's certainly in the CAT and to an extent in the Court of Appeal, because I remember the argument being, well, you had to have a MIF, to which the answer is given here, well, there are card systems which don't have MIFs. And I think from recollection, Amex doesn't have a MIF. Diners Club, I think, and there.
Well, no, these aren't. These are three-party card schemes.
No,
so
that's
they,
right. That's
they,
right.
They
You're
just
quite
don't
right.
have.
There
And
was
strictly,
some
Amex does have a MIF.
There was some
when it
evidence
operates on
somewhere,
that.
and they refer to it here. Don't they? I think there were 5 open card schemes which didn't have MIFs.
These
Can't
are
remember what they were.
small debit card schemes in places like
Yeah.
Denmark and places like that. Dankorp was one of them. So if you have a paragraph like 665, you know, it is still, I would say, a ruling on the specific. Obviously, as it's saying, here are examples of showing, you know, the reasoning is one which is saying clearly you don't need to have a MIF at all in answer to an objective necessity argument, and that reasoning would be of general application. But that doesn't alter the fact that the decision is specific, and you know, it certainly doesn't render the more specific paragraphs, because that's just simply a rejection of objective necessity. 664 is about the MasterCard MIF, I say, and finally that's a restriction for the reasons given. And then what I was going to show you is the similar points in relation to the exemption section, which is in many ways the more relevant one for my purposes, because that's really the crux of this, is has this been ruled out by the sections on exemption?
And was
I'm not fighting restriction again. So these are the paragraphs in the judgment, which
Can I-
approaches.
Can I, just before you do leave it, ask you to look at another paragraph, which is, again, not one of the ones which you rely upon in paragraph 73, and it's paragraph 14, recital 14. This is the publicity requirement, but you do see there 4 lines up from the end. The way the Commission regards what it's requiring MasterCard to publicise is, quotes, the abolition of its intra-EEA fallback interchange fees. That's basically saying you just can't do it, isn't it?
Well, no, and we come back to the fact, it's simply the same point.
Abolition is, yeah, I mean,
But that's, step one is we were being required to abolish, but that's when read by reference subject to the paragraph above that says, unless you can satisfy us, the different level, that, and then you'll be allowed to have it. So yes, it's abolish unless.
you can have an entirely new MIF, but not an intra-EEA fallback interchange fee. So there may be some other design of MIF, which is something that might fall within the very broad definition of MIF, but you just can't, the real objection is you just can't have something that sets a floor. I mean, is that not a fair reading of this? Because that's what basically has been found to be the problem, which is remedied by the order that you must change your rules.
Right, let's say 2 things about that. One, I say that's not the right reading of recital 13. Haven't on that. It's an entirely new MIF other than the intra-EEA. Secondly, by definition, they must be talking about a new MIF that does have that effect, that does restrict competition. Because they then go on to say, provided it can satisfy 81.3. You only get to 81.3 if it's a restriction.
Yeah.
So they are acknowledging that we're going to be doing something probably which is a restriction. It's just an exemptable restriction. So you know, I don't think it can be right to say, and realistically nobody here is thinking about the idea that we would set a new MIF which, you know, the analysis, and this is very much what we've got to with the Court of Justice and the Supreme Court and the Court of Appeal in Sainsbury's, was, you know, once you set a multilateral fee at a sufficiently high level that applies generally, it's going to have that kind of effect in many situations. So I don't think it can be understood from saying, don't do it that it has a floor effect. They're saying, obviously it's going to have a floor effect in all likelihood, but as long as you can show it's justifiable, you're allowed to have that.
No, the problem is, sorry, the problem is that you shouldn't be setting, MasterCard should not be setting the floor. What a MIF is a multilateral interchange fee. It's okay, it may be possible to have the member banks, which doesn't include MasterCard, between themselves in a permissible way, set an interchange fee. The problem is you, MasterCard, can't do it.
Respect my lord, again, it says it does not prevent MasterCard from adopting an entirely new
Adopting?
So it has to be MasterCard taking, you know, MasterCard must be the one who adopts it. And
Yeah,
you know, certainly analytically,
so MasterCard could say part of our structure of providing services is that we won't set a multilateral interchange fee. We will simply leave it to the member banks or an association of them or somebody else to set that fee, because that's what the definition of MIF stands for. In other words, now, it may be possible. There may be all sorts of other problems with the banks setting that fee in such a way, but it may be possible. But it's not MasterCard setting the fee, it's adopting a new structure which would fall under the definition of MIF as set out at page 1620, which involves the interchange fee being set by member banks or a body within an organisation of member banks.
My lord, the problem fundamentally with that is the finding is that MasterCard is an association of undertakings. The undertakings are the banks. So MasterCard has been found to be an association of the banks doing it. So they can't be saying, it's fine for another association of banks to be doing it. And they're talking about this does not prevent MasterCard from adopting an entirely new MIF. That's going to be, and the reality is the specific person who set it, it's never been suggested to be at sort of the critical point at this stage. So, in respect, I say you can't read that as saying somebody else did it, because in reality as well, if that was the case, there might be a restriction at all. So they're anticipating something which will have the restrictive effect. Hence the reason we have to get into exemption.
That's why we need business secret 2A, because I think that will reveal that definition of MIF is by reference to MasterCard itself as an association of undertakings.
Well, it will reveal that. I think all the things that were redacted were the specific individual or committee who did it. But I would say that that has sort of no significance here. I don't just say that as a matter of analysis. The Commission specifically said that has no significance because MasterCard IPO'd in order to try and argue, therefore, that we weren't an association of undertakings, and the Commission said not good enough. So the crux of this is that MasterCard is an association of the banks, and it is saying it doesn't prevent MasterCard from adopting it. So it's always going to be a multilateral exchange fee, a collectively agreed fee they're talking about.
It may be that my problem is just, as the Chancellor has just said, I'm trying to make sense of documents where the critical definitions have been obliterated. So to understand how is it said to work.
I apologise for that.
Should we move on?
Yeah, well, move it on. But the bits I wanted to show the court in relation to exemption, and it starts at paragraph 120 in the
This
judgment.
is in the judgment, is it?
The judgment, yes. And just to by way of preliminary, my submission here is the analysis each time is we're looking at the MIF, the actual MIF, and the Commission saying, here's the reason for the MIF, this is the evidence for this MIF is not exempt, or we failed to do it.
So where are we?
So it's paragraph 120 of the judgment. So these are recitals
The judgment.
from the judgment, page 179. And it quotes a number of recitals from the exemption section of the decision. So 668, the starting point for the Commission's assessment is MasterCard's arguments as to the purpose and function of its MIF. So that's recital 669. Yet again, reference to MasterCard defines its MIF in the fourth line, its MIF, 669, second line, MasterCard clarified that its MIF is not a fee. So again, it's talking about the specific, it's say. If we then, there are various bits sort of analysis, 124. Now, so 124 just refer to that. So it says, hence, whether a MIF should be paid by acquirer to issue or vice versa, or whether it should be set at a certain amount or zero, cannot be determined in a general manner by economic theory alone. So it's explaining the point, you can't just look at MIFs generally, which is the point in my favour. It's saying you need to actually have the evidence in relation to this specific MIF. Which is what
you say that's in your favour. Can I ask you this? MasterCard's application for exemption was in relation to the rules and any implementation of the rules by individual decision, setting any level of MIF, including one at 0.1, fractionally above zero.
No,
Isn't that effectively the entire structure of the analysis? You applied for exemption for any level of NIF which was set? Because it doesn't that necessarily follow from the way in which the argument was put to the Commission.
Well, no, there's a difference between what was before. What the Commission had to decide was whether our actual MIFs that were notified. We notified, said, you know, these are our rules, these are the MIFs that we set, we updated them. So that is what the Commission
Well, I'm not
then
certain
ruled
about it.
upon. And there's a difference between whether how MasterCard tried to justify that, which it failed to do so, but we weren't, you know, the notification was of the specific, not some generality.
But the application for exemption was of the system as a whole, which included the setting of any MIF. You know, I mean, just to take one example, paragraph 674 on efficiencies and technical and economic progress. MasterCard claims technical and economic progress of the MasterCard system is achieved as a result of the MasterCard default MIF. In other words, the implementation of the MIF system at any level. There wasn't an attempt to justify it at level X or Y or Z. It was the entire system, which included the way in which any level at which the MIF would be set.
Well, there's a difference here between the arguments that MasterCard advanced to try and justify the notified MIFs. We were trying to say level shouldn't matter, versus what the Commission concluded. What the Commission concluded was level does matter. You need evidence justifying this level, and this MIF has not been justified. This MIF is not exempt. That's what I say is the where you get to.
Understood.
So, and the fact that we argued it in a way which obviously failed may be relevant when we come to abuse, I say. But here, when you look at what the Commission decided, it said, no, you need to justify level, which is the next paragraph 125, recital 700.
The worst way it could be put against you. You applied for exemption for a MIF system which was capable of setting the MIF at 0.1, and you failed.
Well,
Necessarily.
I mean, the answer is, I don't, I'm not sure there is any basis to think we did do that. The Commission, if we'd done that, it's quite clear what the Commission thought we were doing, which is the Commission said, no, you need to justify your actual MIFs. We're not thinking about theoretical, you know, everything under the sun. It might be 10%, 20%. You have to justify this MIFs, and that's paragraph recital 700, which is 125, which explains that. So it's 690 that explains a claim must be founded on evidence showing the benefits of this MIF, and then we see 700, 6 lines down, you know, none of these materials contain empirical evidence that would enable the Commission to assess how, to what extent, the MasterCard MIF continues to affect the efficient balance of cardholder and merchant demand. In conclusion, the MasterCard MIF does not meet the first condition of Article 81.3. So, you know, to some extent, these are all going to come back to my definite article point. But in each case, you know, yes, MasterCard tried to say you don't need to worry about the specifics. The Commission came back and said, no, you do need to worry about the specific level. Yeah. You haven't justified this level, so this level is not exempt.
Not just what, which of the words you say. In the first part of 700 is a recitation of documents and analyses put forward, which it says doesn't justify the MasterCard MIF, in other words, the system in it and the implementation thereof. Where do they say you haven't sought to justify it by reference to actual levels of MIF?
Well, so you read basically 690, which is the paragraph above, says you cannot determine this in a general manner. You need specific evidence. 700 then says there's nothing that will allow us to justify the MasterCard MIF. In conclusion, you haven't shown the MasterCard MIF meets the first condition. And if you go over the page, oddly enough, they do the first condition twice, slightly surprisingly. And 731, I would say, is the paragraph that is most obviously makes this clear. Contrary to MasterCard's perception, the Commission's position is not only that the level of a MIF is a decisive criterion, the existence of objective appreciable efficiencies is assessed in relation to the MIF as such, the effects it produces on the market and the manner in which it's set. So, yes, MasterCard tried a broad case, and the Commission said no, it needs to be justified by reference to the MIF as such, the effects of that MIF, the objective benefits, and then 733, which is oddly the conclusion again, the MasterCard MIF does not meet the first condition of Article 81.3. So with all of this, we say what the Commission has decided is you need to justify the specific number based on that number having benefits that outweigh the disadvantages of that number.
But I mean, what 731 demonstrates, it seems to me, is the Commission saying in terms, it's not just the number. So in other words, going back to your point about 13, they're not saying, well, if you change your number, if you come down from whatever it was, let's say it was 10, come down from 10 to 3 or 4, whatever, then your MIF will be exemptable. 731 is saying, contrary to MasterCard's perception, the Commission's position is not that only the level of a MIF is a decisive criterion for assessing whether that MIF fulfills the first condition of Article 1013, rather the existence, and then he goes on and he identifies all sorts of aspects of how the MIF is set and how it's determined by reference to underlying models and methodology, which the Commission, would expect to be, as it were, capable of review, so that the Commission might decide in the future that the way in which it was set was not just its level, but the way in which it was set was legitimate, exemptable.
Well, it's certainly talking about the fact that they're not saying we just like a lower number. They're saying you have to show that a particular number has certain benefits which outweigh the disadvantages, and it needs evidence. Yes, justifiable. Yes,
justifiable.
But but that is essentially my point. That the Commission says you need to do it in relation to the MIF as such. You haven't done it. And then 733, in conclusion, the MasterCard MIF does not meet the first condition of Article 81.3. We said its conclusion twice. Again, 735, direct benefits of its MIF, the MasterCard MIF.
I mean, it's right at 732, which you moved over.
Yeah.
I mean, MasterCard was basically saying any MIF which we set, doesn't matter what level we set it at, will balance the demands of cardholders and lead to a better performance of the system is inherent and indispensable. I mean, it's any old MIF. It doesn't matter what the level is. We need to be able to set a MIF.
Which includes 0.1.
And the Commission rejecting that approach and saying that's not.
Yes, the Commission is saying you can't just say any old MIF's good enough. You need to have evidence showing the benefits of the particular.
Yeah,
and then it says you haven't shown any benefits of this particular MIF.
Well, but then
so it has
as a consequence, just dismantle your system.
Subject to my recital 13.
Well, yes.
So what I do say each time it is, in conclusion, the MasterCard MIF doesn't meet the first condition of 733. The same kind of points going through. 748, MasterCard claims its MIF is indispensable. Each time it is a ruling in relation to each of the conditions that the MasterCard MIF doesn't satisfy. So the Commission is doing, as I said, what I started with. The Commission is saying, no, you have to justify this MIF. That's our job. That's what you've put in front of us. You haven't done it. And we say, but that is completely different from then making a positive ruling that there is no lawful MIF above 0.
Okay.
So,
nice.
Just finally, I know we're going to go the same ground. 751, the conclusion, assessment by the Commission, the second half, rejecting the MasterCard argument, payment card systems in the EEA have successfully been operating without a MIF for a long time. Established 79 to 92, viable, successful based on ECB statistics. I mean, that's everything from 0.1 upwards, isn't it?
In relation to whether that's essentially a repeat of the objective necessity point. That doesn't mean that you wouldn't still have appreciable advantages from a MIF, which would be the first condition, and those might then be indispensable. The MIF might then be indispensable to those additional benefits.
Okay.
So, I mean, standing back, we say Article 1, read in accordance with its purpose, its words, is about the specific. That is the ruling. They have said repeal, but made clear that it is, we can bring forward a new MIF. Nothing about that suggests, consistent with their role, they were saying any MIF above 0 is unlawful. Therefore, the only ruling is a positive one, or negative one, that the particular EMIF was unlawful. And what I seek to do, with advance, is a case which is not a contradiction of any part of that, because it is bringing forward exactly what I say, a new MIF, where we would provide the specific evidence of that level as having appreciable benefits. And we do say that is entirely in keeping with the limited role of what the decision has decided and necessarily decided. So I think I probably addressed as much as I can on Articles 3, 4 and 5, which you all say have to be read fundamentally subject to Recital 13. We do also rely upon paragraph 165 of the judgment, which is in the abuse section, which I'll obviously come to, which is here no consideration by the Commission of what level of MIF or modified rule might qualify for exemption took place. Now, with respect, we entirely agree. There was no consideration by that. The fact there was no consideration of it demonstrably follows from that the Commission cannot have positively ruled that any level of modified MIF or modified rule would not qualify. We just haven't considered that question, which is, we say, confirmation of exactly what I've just been arguing, is that all of the hypothetical alternatives were not before the Commission. The Commission didn't rule them, and therefore we are not asking to do anything which cuts across what they actually decided in relation to the actual EMF. So we say in that paragraph of the abuse ruling, at least the tribunal is absolutely right, and that sums up essentially my submission, which is taking me rather longer a reference to the detail. We do rely as well upon the general approach to assessing damages for tortious wrongdoing, the ruling of this court in Sainsbury's in relation to, it's fair to say, standalone cases, but nonetheless, what we say is the right approach. They say there, you look at 101.1, 101.3, and ultimately the question for a court in a damages case is what part of the MIF is unlawful, and you assess damages accordingly. That's a conventional application, we say, of standard damages principles, looking at the extent to which the wrongdoing has caused harm. And it's exactly what should be the position we're trying to do here. And it reflects the fundamental difference, as I've said, between the role of the Commission, binary good or bad, versus the role of a court hearing a damages action, which is to say, fine, the necessary starting point is there is an infringement. Now let's look at the extent of that. Extent is not relevant to the Commission. It is, once you get to this stage of damages, and then you have to look at the alternative. And that might be all sorts of things. Cartel case, it's just what prices would have been in the competitive market. Here it's a potentially lawful alternative. Potentially lawful way of running our business. And it could be bilateral interchange fees, it's not factually, or it could be
why is
lawful alternative.
Why isn't the counterfactual just let the acquiring and the merchant banks sort it out between themselves, and you just don't set the floor?
I'm afraid there's a very long answer to that one, in the sense that these points have been fought out at considerable length, and the Commission expressly considers the bilateral alternative, which causes significant problems in certainly the wealth that's being looked at. In a nutshell, the problem that arises is, firstly, the number of people there, secondly, more importantly, that they're forced to negotiate, and you have this difficulty of, that number might be 5%, might be 10%, and that the competition, this is the Commission's analysis and conclusion, that competition between issuers will tend to force that number ever higher, because every issuer wants more money. It has, the analysis is the whip hand in the negotiations, and so the number would just go up and up and up. So the Commission actually positively dismisses bilateral negotiations.
Why isn't that a good, why wouldn't, in these proceedings, these collective proceedings, why isn't that counterfactual good for you? If that is the counterfactual, as opposed to trying to say we would have got away with setting a floor at a different level, I can't understand why that counterfactual that you just explained is so bad for you.
Well, it wouldn't be if it was realistic. But we're not in a position to say that we would, in that time period, have run our scheme in that way, because what the Commission concludes, and MasterCard didn't disagree, was if it goes up and up and up, it gets to the point when if you try to persuade merchants to accept credit cards when there was a 25% fee, the scheme falls down. And that was the Commission's analysis.
Sorry.
You'd end up without credit cards, basically.
Yes.
So you'd end up losing by another route, as it were.
Well, I don't think we'd end up. Sorry,
The whole
in fact,
system
in this
would
case
colla-
would
whole
be
system would collapse.
Yeah, the whole system would collapse. But as a result, the Commission said that can't be a realistic counterfactual, and the Court of Justice agreed. That can't be a realistic counterfactual because MasterCard would never do that. Would never positively do something that would destroy our business. That's why we're not positively saying this should be assessed on the basis of we would throw our toys out of the pram and collapse our entire business.
Yeah.
We're only talking here about what the counterfactual is. You say the counterfactual is something which would have been exemptable and which the Commission would have exempted. If we construe the decision as precluding that, you're still left with any other counterfactual. Now, it might be the worst one, which is the counterfactual is what you charged, but it could be bilateral interchange if there was evidence and if it was viable. In principle, it's available to you. It may just not work on the facts.
Absolutely. And there are other points we make, which is other changes to scheme rules and things like that. So, that's the case. There's no suggestion we're not allowed to run other parts of things will be different in the counterfactual. One of the things we say, for example, is a lot of business would switch to American Express if we were uncompetitive.
Yeah.
So those kind of points. But so this is simply whether the question is, are we allowed to run a point which is about lawful alternatives as opposed to other things which
This is just
we
one
accept we can't.
alternative. I mean, the claimants will say the overcharge is the overcharge, it's the difference between zero and what was charged. You may say it's something else. This is one of those something else which might or might not be precluded. That's all it is, really, isn't it?
It is, it's an important one for us, but yes,
absolutely.
otherwise we wouldn't be here. But
No,
yes,
understood.
but yeah, there are, as you'd expect, we have a number of
course.
lines of defence, but this is one the
Yes.
tribunal's sort of stopping us running
Yes.
ab initio.
Yeah. Okay.
So we do rely upon the general principles of tort. We rely Korean, I think you take this court to that, which is a decision of the European Commission only applies to the agreements, decisions or practices subject to that decision. To some extent that begs the question. We do say the agreement is the specific EEA MIFs. I've had my submissions on that
In
point.
that case, the difference was that the claimants were trying to rely upon a decision to which the defendant wasn't a party.
It is. But it's we rely upon the principle rather than the specific example in that case, but it shows a commission decision is about, which I say is in any event obvious, the specific thing notified to it in front of it. Whereas in our situation, so we are dealing with something which would be putatively something different. Because my learned friend says it will be the same arrangements. We say it's not. If it's significantly different, we're obviously not going to do something that's, something that's not materially different, that would be the same. But if it's materially different, significantly lower, it's not the same arrangement. So it is something that's not covered by the decision. And then we come back to also Visa, MasterCard's 2009, as showing, again, the idea that the Commission positively ruled that there was no lawful level of NIF above zero just cannot stand in circumstances where it's just issued an exemption decision saying NIFs that were 30% lower were lawful. So you have to understand it in that context. I mean, what they could have done if they said we've now changed our minds, but it's quite clear they haven't to that extent. They refer to it without saying they changed their minds. So you can't read it as a positive ruling of everything above zero is unlawful. They just accepted that it can be. So those are the points in relation to the Commission decision. brings me then to the abuse of process ground of appeal. My first submission on this is that the tribunal misunderstood and with respect misapplied the law of abuse of process. And it's important here to distinguish between two kinds of abuse, or two lines of authority about abuse of process. First, there is the situation in which an issue has already been decided in previous proceedings between different parties, and one of the parties to the earlier action seeks to re-argue the point in proceedings with a different party. And I'm going to call that's the Volvo situation, most recently, the decided point different parties abuse. So a point has been decided, but between different parties, whether you can relitigate it. And then there's secondly the situation in which there are previous proceedings between the same parties, or their privies, and one of those parties seeks to raise an issue in new proceedings, which they could and should have raised in earlier proceedings. That's Henderson and Henderson. And that is called undecided point between the same parties, same functionally treated as the same parties. And just to sort of cut to the crux of what I'm going to be saying here, we are in a third category. We're talking about undecided point, different parties. And I'll be simply saying the law does not recognise that as abusive. So that is the crux of it, is there are two lines of authorities that deal with situations that are much more limited, and so the undecided point of different parties just simply is not a category of abuse. Just to sort of show you the law very briefly, people are familiar with it. Firstly, the law on decided point different parties. So Bairstow is one of the sort of the origins of that. That was a case where the director had brought a wrongful dismissal action against a company. He'd lost, he made grave findings of misconduct. The Secretary of State tried to rely upon those findings in directed disqualification proceedings. So decided point, different parties. We can pick up sort of the principles we get from that from the Volvo case, which is tab 37. And again, just to, again, I recognise members of the court in particular will be very familiar with this, but will be anyway. So Volvo was again a situation, so it's directly applicable here, directly more applicable. It's a follow-on action that a decision had been made by the Commission, in that case a settlement decision, so the parties had agreed to it, and then in follow-on damages action, they tried to re-argue points that the settlement decision had decided against them. But again, that is simply, that's how the court treated it, a case of decided points, different parties. They have been decided against them. That's a scenario. If we go to 139, paragraph 139 of this judgment, which is the decision of the then Chancellor, which starts off by repeating the section from Hunter, and then the second half of that paragraph, where the parties to the two proceedings are not the same, it will only be an abuse of process of the court to challenge the factual findings of the earlier proceedings. It will be manifestly unfair to a party to the later proceedings that the same issues could be relitigated, or to permit such relitigation would bring the administration of justice into disrepute. So those are sort of the two limbs of the decided point different parties case. And there's also a section from paragraph 103, which is a judgment of Lady Justice Rose. Which he, and the second half of that, the CAT referred to cases emphasising situations in which it would be an abuse to litigation issue which had not previously decided between the same parties would be entirely exceptional. That's more Justice Flo's Wentworth and Komoke, and for Rare Health House in Merricks. These are all decided cases, different parties. The standard, of course, is very high, entirely exceptional. Now, Volvo was a case in which the court decided that that entirely exceptional situation arose because there was a settlement agreement, the points had been decided and the parties had accepted them. But the sort of the target in that line of authority is that manifestly unfair or would bring the administration of justice into disrepute, which is the Bairstow test. And then I turn then to the second line of authority, which is the Henderson, Johnson and Gore Wood, which is, I would say, point undecided, but same, or functionally the same parties. And we take that from Johnson and Gore Wood, which is tab 18 of the authority bundle. And which I thought we're very familiar with the facts of this. So this was a situation in which Mr. Johnson said the company that he owned had brought certain kinds of litigation, it had lost, and then he as an individual was trying to bring claims against the same defendant, running points that could have been run as part of that previous action. There are two substantive judgments on abuse of process here. There's the judgment of Lord Bingham. There's also that's with the other three law lords agreed with Lord Bingham's judgment. There's also the judgment of Lord Millett.
Yes.
They reached the same conclusions on abuse of process for similar reasons. So this isn't a majority-minority situation, but two substantive judgments in agreement. I'm going to start with the Lord Millett judgment, just because it makes this point most pithily, but I will be showing you that Lord Bingham, my submission, decided the same point. So if we can pick it up as page 58 of the bundle, of the judgment, which is explaining sort of the abuse of process argument. Middle of the page, it starts with the famous quotation from Henderson. Goes through some of the history below it. At the bottom of the page, Lord Justice May observed in Manson versus Voigt, it's not concerned with cases where a court has decided the matter, but rather cases where the court has not decided the matter. These various offences are all designed to serve the same purpose, to bring finality to litigation and avoid the oppression of subjecting a defendant unnecessarily to successive action. And that explanation, I'm saying, is it's very important because it's the successive action causing prejudice to a defendant, which is critical to the Henderson abuse test. And then if you go down to the middle of subparagraph C, it says, however this may be, the difference to which I've drawn attention, and the difference is it's undecided issues as well as decided points. He says it's of critical importance. It's one thing to refuse to allow a party to relitigate a question which has already been decided. Quite another to deny him the opportunity of litigating for the first time a question which has not previously been adjudicated upon. This latter, though not the former, is prima facie a denial of the citizen's right to access to the court, conferred by the common law and guaranteed by Article 6 of the Convention. So he's drawing the distinction there that opportunity of litigating for the first time, that's something that really parties should not be stopped from doing. And then if we go down to just above subparagraph F, in Brisbane City Council, Lord Wilberforce explained that the true basis of the rule in Henderson is abuse of process, and observed that it ought only to be applied where the facts are such to amount to abuse, otherwise the danger of party being shut out and being forward a genuine subject of litigation. At the bottom of the page, the last few words, the burden should always rest upon the defendant to establish as oppressive or an abusive process for him to be subjected to the second action. That's the focus of the Henderson abuse. The rule in Henderson cannot sensibly be extended to the case where the defendants are different. Then there is no question of double vexation. So now there is a point about same party, which is, as this deals with situations where parties are essentially the same, privies, like in this case his company, Mr. Johnson's company, the company he controlled, brought the litigation. But apart from the narrow point of privy, what's being said here is the rule in Henderson cannot sensibly be extended to cases where the defendants are different. We say that clearly explains that that is a doctrine which is undecided point, same parties. And the reason is there's no question of double vexation. So that abuse is about, Henderson is about doubly vexing the same person, and you can't have an abuse beyond that itself when it's not the same parties. So we say what you then get is, as I've said, two kinds of abuse. Decided point, different parties. Undecided point, same or functionally the same parties. We are in the territory where there's simply, that makes clear, no abuse. Undecided point, different parties. I said I'd show you as well the judgment of, the main judgment, just to make clear that it has the same limitation as well. If we go to that, it's Lord Bingham, it's page 32. The judgment. We started off at subparagraph C. It says, two subsidiary arguments were advanced by Mr. Terhar in the courts below and rejected by each. The first was the ruling Henderson didn't apply to Mr. Johnson since he'd not been the plaintiff in the first action. He says, in my judgment, the argument was rightly rejected. A formulaic approach to the application of the rule would be mistaken. And then at the end of that paragraph, the correct approach is that formulated by Sir Robert Gary, Vice Chancellor, in Gleeson versus Whipple. If you could, the court could read that paragraph.
That's the other way around, though, isn't it?
It is slightly, but it seems to be the, being relied upon.
Mr. Johnson was the alleged abuser in this scenario. I thought your first point, which I understand, is that you can't have Henderson abuse where the defendant is not the same, because he's, there's no question of him being vexed twice.
Absolutely.
Or sorry, the other party, whoever it is.
Yes, and this paragraph is explaining the sort of the same party point. It's saying the principle applies when they are functionally together. There's a sufficient degree of identity. So it's what I'm trying to show here is that Henderson is limited to the same parties, or functionally the same. So the argument was the rule doesn't apply because because Mr. Johnson.
Well, it's either the same parties or where there's privity of interest. That's the,
Yes.
which from recollection was the Komoka position.
So was the
from recollection was the Komoka position. I can't now remember. I'd need to look at it.
yes.
But I remember looking at all these cases, including Gleeson and Whipple.
Well,
Putting it simply, a defendant who is a party to both sets of proceedings can say, in the second proceedings, you, Mr. J, Mr. Johnson, cannot run this argument against me because your company should have run it against me in the first set of proceedings and you chose not to.
absolutely. But as a result, it's a principle that applies where there's the same party situation, or sufficiently the same party situation.
Well, what you're saying is, if the person wanting to raise the Henderson abuse argument actually wasn't a party to the first proceedings at all, they can't run it because they've never been vexed twice.
Absolutely. So that is where I come. So what I'm showing you is they've explained the principle.
Yes.
Henderson applies same party or privity of interest, privies, and so Lord Bingham has agreed with the test, which is same party or privies, and then I've showed you Lord Millett has sort of clarified it more pithily to say it cannot apply where they are different parties. So what I'm trying to show you is therefore the abuse rule for undecided questions is only whether the same or privies. And this is the situation in which that is not open to Mr. Merricks, who was not a party to the initial proceedings.
I mean, I'm slightly puzzled because I thought the bit you were going to take us to is the bit at the top of bundle page 165.
which I was going to come back to now as well. But what I'm doing at the moment, I'm going to do so because that's a sort of, and that will probably make after that a good moment to finish for short adjournment. But what I'm showing at the moment is there are two principles of abuse. One is, say, decided party, different parties, decided point, different parties. Here, undecided point, same privies. There is not a third category, and Lord Millett makes very clear why, that you don't get undecided parties, different parties, undecided point, different parties. There is then a different point in relation to Lord Bingham. I mean, firstly, he explains Henderson at the top of page 31. Finality of litigation of the party should be not twice vexed in the same matter, which you'll recall is the crux of Lord Millett's rejection of Henderson having a scope in a different party scenario. And it was the paragraph in the middle that I was going to come to. If there's a question that the court has in relation to a higher bit, I can address that. But it was it's the paragraph that there may be an aspect of the tribunal looking at it and saying it provides a bit of a sort of open field day for this area. But I would say it's not. It's actually, if we start at just below subparagraph C, it's wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. That is to adopt too dogmatic an approach to what should be a broad merits-based judgment. But the point about that is you're in a territory where it's a point that could have been raised earlier. You're in same parties, so you're in Henderson, and then what Lord Bingham said is it's not an automatic abuse. You need to look at the reasons it wasn't raised earlier, take account of those factors, so you may decide it's an abuse or it may not. So it's not a blanket abuse is a general test of parliamentary justice. It is, once you have actually met those basic conditions, it's a point that could have been raised earlier. You then still have to think about it to consider whether it is in fact an abuse. But it's a point that doesn't arise for me, as I said, we're simply not in Henderson to start. So I've probably got another 10 or 15 minutes to do after lunch. I mean, the sub-point on this is going to be very simply, showing you the two lines of authority. We say, this
We
simply...
just say it isn't within either of the recognised categories of abuse, and that's the end of it. Although there are cases that say the categories of abuse are not closed. So
There are, but that's because people aren't ruling out scenarios.
No.
But there's a difference when you say there might be some situation no one's thought of yet, as opposed to when you've seen Lord Millett, for example, saying Henderson doesn't apply in this situation. So it's a situation where I'd say that there is a specific ruling point.
Before we left the EU, because national courts had to pay due regard to commissions of the decision under the principle of sincere cooperation. So there was that link, and a lot of this case law really didn't have the same bite. Now we're no longer in the EU. The principle of sincere cooperation doesn't provide. But we still have a regulator who took decisions on behalf of consumers. There are theoretically rights of intervention. I don't remember whether any consumer bodies intervened, but wouldn't be this class. We've got section 58, which says that decision has a preclusive effect in national proceedings. So is it right to try and squeeze this into very traditional domestic pigeonholes?
Well, to some extent, the answer to that is Volvo. Because what Volvo does is it's a two-stage judgment in the Court of Appeal. Step one, they go through what are the European law principles of which parts are binding, and obviously, the principle is it's not the decision as a whole which is binding; it's the dispositive at the end plus the necessary parts, the reasoning and points like that. So the court in Appeal in Volvo does go through and say, how far do we get under European? Under European law, that wouldn't have been a problem in Volvo. And then they say, right, in which case we now look at English law, which in the fact of those circumstances went further. So there's no suggestion here, subject to the point, the first point. Obviously the first point is that, which is if there's a ruling, that's the end of it. But therefore we do. If, and I say is absolutely right, because the tribunal said no consideration by the Commission of what level of myth or modified rule might qualify for exemption took place. So there is no ruling. We then come back to conventional principles of abuse of process, which is how the tribunal approached it, but in a way that didn't actually follow the conventional rules of abuse of process.
Right. So you think you need another 10 or 15 minutes, Mr. Mitri?
Well, I'll cut my cloth, so I think the hard stop is 3:30.
Well, I only ask because I mean, obviously we've interrupted quite a lot. I'm conscious of that, and I could make some phone calls and so that we could sit certainly until 4.
Well, let's try and finish by 3:30, which was the plan. So if Mr. Cook can be another 10 minutes, I'll try over the short adjournment to.
Yeah. Well, we've got a lot of the points already.
I know, so I'll try and cut down what I was going to say.
Well, I don't want you to feel that you haven't had a fair
won't.
crack of the whip, etc. So if we find that you need more time, then you need more time.
I'll do my best. I think it should be okay.
Right, so at 2 o'clock, please.
Court rise, if able.